morning. We are on the record in cause number F1875401, which is the state of Texas, versus Billy Shamirmir, and the offense is capital murder by terror, threat, or other felony. We are resuming the trial today. However, we will start this morning with several pre-trial hearings outside the presence of the jury. And state you may call your witness for the purposes of this 702, 705 hearing.
Thank you, Judge. State would call Agent Mark Sedgwick.
All right. If you please raise your right hand for me. Do you so solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You may be seated. You are welcome to testify with or without your mask.
Thank you, Your Honor.
Thank you. You may proceed, Mr. Anastas.
Thank you, Judge. Good morning, Agent Sedgwick.
Morning.
Will you please introduce yourself and spell your first and last name?
My name is Mark Sedgwick. Last name is Mark with a K. Last name is Sedwick.
And I've already said Agent Sedgwick, so how are you employed?
I'm a special agent with the Federal Bureau of Investigation out of the Dallas office.
And how long have you been an agent with the FBI?
23 years.
What was your background leading up to joining the FBI?
I was in 1993 graduated the United States Naval Academy, and then I was in the Marines for 5 years, and then I came to the Bureau in '98.
And I guess since joining the Bureau, what positions have you held?
I've been a special agent the entire time, working mostly in narcotics and violent crime, with small stints in CT, counterterrorism, and public corruption. But now I'm assigned to the CAS team, which is the Cellular Analysis Survey team.
And what exactly is the CAS team?
The CAS team is a group of specially trained agents and task force officers who have been certified as experts in the analysis of historical call detail records.
And so, as it relates to criminal investigations, these historical call detail records, these phone records, what does the CAS team have the capability to do with them?
Based on the call detail records and the contemporaneous hour list, I can determine the approximate location of a device when a call or text was made or when other events occurred, depending on what type of records I have.
And basically, these cell phone companies maintain these business records for their own purposes, but law enforcement, like the CAS team, is able to use them for a different purpose, to give the location of a cell phone device. Is that fair to say?
Yes, sir, the approximate location.
And the types of records, you mentioned call detailed records, but does that also include timing advance records?
Yes, sir.
Okay. What specialized training and experience do you have to be able to do something like this?
Initially, I've had over 400 hours of training. That training has been from other FBI agents, outside agencies or companies on how radio frequency or RF energy works, which is how a cell phone communicates with the cell tower. But most importantly, I've been trained by the engineers from all the major service providers in the United States, AT&T, T-Mobile, Verizon, on how a cell phone works, how a cell phone interacts with the network, and how the network is designed and built and operates.
And how long have you been doing this as a member of the CAS team?
Took my first training in 2007. CAS became a unit in 2012, and I was certified in 2014.
And you told us that you're part of the Dallas office. Is this CAS team something that is, I guess, within the United States, multiple locations?
Yes, sir. There are about approximately 70 certified CAS agents and task force officers throughout the country. In Texas, there are 5 of us now. We just recently, maybe a month ago, got another agent certified in Dallas. But for several years, I was the only one in Texas.
Do you have any kind of estimate how many times that you've been asked or have reviewed records such as the ones you were describing and approximated a cell phone location from that data?
Thousands of times.
Has that led you to testifying? I guess you said you were at one point the only agent in Dallas, so did that kind of spread you out around the courthouses here?
Yes, sir. I've testified over 80 times in both state and federal court throughout Texas and several other states.
You talked about your training, your experience, and your background. Concerning all that and your real life experience, have you found this type of analysis to be reliable?
Yes, sir.
And so what specifically do you base that on?
I base it on my real-world experience of taking historical call detail records and then being able to locate a device, to locate that kidnapped victim, the missing person, the homicide victim, fugitives. I use these records. CAST unit uses it probably almost daily to locate individuals based on their cell phone data to locate that device.
And you already told us, with your training from the actual phone carriers, so the knowledge that you've gained and learned from the cell phone carrier themselves, does that also give you that confidence that what you're doing is reliable?
Yes, sir. We have a yearly recertification, and we will bring in representatives, engineers, and other representatives from all the service providers yearly, so we can know kind of what's the upcoming, like when 4G was starting to roll out, now that 5G is starting to roll out, how that's going to affect the networks, how that's going to affect what records we're going to receive from the phone companies, issues like that.
And including in that training, is that from the cell phone companies telling agents like yourself how to interpret those records?
Yes, sir.
You mentioned real-world experiences. Have there been occasions where you have reviewed call detail records, time advance records, and during an ongoing investigation where that's been used to actually find a victim or to locate or apprehend a suspect?
Yes, sir. I've recovered kidnapped victims and found fugitives and located missing persons using this real time.
And have there been multiple occasions where you've reviewed independently these types of cell phone records and then found out that your conclusions were corroborated by other types of evidence, such as video evidence or witness statements?
Yes, sir.
Does that happen often or just a few times?
Very case dependent, but fairly often.
Is that something you also consider into telling us that, you know what, this is reliable?
Yes, sir.
And so, were you asked to review cell phone records of a phone number belonging to Village Mirror 972-674-7527?
Yes, sir.
You're a back first witness?
You may.
And so I'm going to show you what's been marked as the Exhibit 319. Do you recognize this exhibit?
Yes, sir.
And how do you recognize this?
That's a disc that contains the records that I use for my analysis.
And State Exhibit 320. Do you recognize this? For the record, 320 is a 26-page exhibit.
Yes, sir. This is a report I'm prepared.
And the report you prepared, is that based on your review of what was marked as State Exhibit 319?
Yes, sir.
And we talked about the types of records you generally review as a special agent with the CAST team. The records pertaining to State's Exhibit 319, does that include call detail records and timing advance records?
Yes, sir, it does.
Were you able to review the records from State Exhibit 319 and determine an approximate location for that cell phone number, that cell phone device belonging to Village Mirror?
Yes, sir, I was.
And so, the State Exhibit 320 you said was your report?
Yes, sir.
Okay, that 26 pages that I mentioned?
Yes, sir.
Okay. Would that report be useful and helpful to understand your testimony regarding the location of that device in relationship to the cell phone towers being utilized?
Yes, sir, it would.
Furthermore, were you asked to also plot or map some places of interest?
Yes, sir, I provided specific addresses, locations of interest to the investigation that I also put on the map.
And generally, cell phone records, you agree, are pretty voluminous?
Yes, sir.
Okay, so, I mean, you may have 2 years, 1 year, and thousands and thousands of pages of cell phone records.
In some cases, yes, sir.
And what you're able to do in your report is to summarize those specific dates you're asked to interpret. Is that fair to say?
Yes, sir.
Okay. And by doing that, you allow us to conveniently or very easily understand those records for those certain dates.
Yes, sir.
Your Honor, at this time, State would offer State Exhibit 320 for all purposes.
Your Honor, we object. Ask for a hearing.
We're in hearing.
We're doing the hearing now.
Okay, Your Honor, may I take the witness on board now?
You may.
Agent, is it Sedgwick?
Yes, sir.
I'm Mark Watson. I'm going to ask you some questions that hopefully you can answer yes or no. You call this a report, correct?
Yes, sir.
Isn't it more of an exhibit than a report, wouldn't you say?
No, sir, there's a written report of a summary of my conclusions on, I believe, the second page, and then it's a presentation of my conclusions.
But a lot of it is in the form of an exhibit to show to a jury, correct?
Yes, sir.
Or a presentation, correct?
Yes, sir, it's my report.
Would you agree that you could have written this out in paragraph, sentence form, without the images?
No, sir. I could write that, but it would be very voluminous and would not make sense to a jury.
But that's not my question, sir. Objection, non-responsive. You could have written it out, paragraph and sentence form, correct?
I guess I could have, yes, sir.
Thank you. The distance that you, Dimitri, would you pull up the exhibit?
You want me to publish certain pages or?
Well, just so-
Okay.
May I approach, Judge?
Yes.
Agent, and I'm showing page 7 where it says January 30th, 2018, 10:05 a.m. Agent, what are those radial bars signify?
That's the time in advance.
Okay. Where does it show the possible distances that the cell phone could be?
That's the distance from the tower, that arc, and then it's written next to the distance based on the time.
Okay. Isn't it true that it's possible these distances could be much greater than that?
No, sir, not based on the time in advance. Time in advance, now if it was just a CDR on the cell site, I can only say the phone was in the coverage area of that particular tower. Based on the time in advance, that also gives me the distance from the tower.
So there's no way that the cell phone can be further away than where it's depicted on this image?
Based on the time in advance, no, sir.
And the time in advance is the methodology you use, correct?
No, sir, the time in advance is one of the records I received from T-Mobile.
Okay, what I'm asking you is it possible that regardless of what methodology you used, time in advance, is it possible, physics-wise or radiography-wise, that this cell phone could be further away than is depicted by these radiated circles?
No, sir, because the time in advance measures the time it took the signal to go from the tower to the cell phone and back, and that computes that distance.
On page 4, you have images that look like a baseball diamond, so to speak, first and third base.
Well, sir, that's showing the coverage area of the cell tower of the highway. Yes, sir.
Thank you. That was tough. Okay, so assuming that, and what I mean by first and third base, you've got a point and then a line radiating, pointing to the left, call it third base, and another line calling it first base, generally speaking.
Yes, sir. That's showing the 120-degree arc coverage of that cell
All right,
tower.
thank you. Now, isn't it true that that line is more of, in actuality, is more of a blob area or an undulating area than a straight line. Isn't that true? In actuality and in practice?
Yes, sir, if you let me explain.
Yes or no question?
Sir, I can't answer that with a yes or no question.
Objection, Your Honor. I'm asking you a yes or no question. Isn't it true?
Judge, I'm going to object. The witness has stated this is not a yes or no response.
And Mr. Watson, if he cannot answer that yes or no, we can move on, or you can ask it in a different way or rephrase it, but I believe in the structure of the question, maybe it could not have been answered in a yes or no.
Let me rephrase that. Sir, isn't it true that in practice and in reality, this line is not always a straight line, correct?
Yes, sir.
So it can be more wavy, correct?
Yes, sir.
Or more of a blob, correct?
I don't like the term blob, but yes, sir.
Okay. So that's not accurate to depict how things can be in real life.
It's accurate because of the reputation of the approximate coverage area of that tower.
But a minute ago, you said that it could be wavy or like a blob. You didn't like that line. But is that correct?
Yes, sir, the actual footprint on the ground will be different.
Thank you. Sir, different things can affect a signal coming back and forth, correct?
Yes, sir.
Building, correct? A building can?
Yes, sir.
Temperature,
Very minimal, if at all.
but it can affect it?
Very minimal, if at all.
Is that a true or false statement? Can it affect it?
Judge, I'm
Somewhat.
going to object. He answered the question. Can we continue on with the next question?
Sustained.
So minimal means some, correct?
Yes, sir.
Thank you.
Tone.
Your Honor, if the witnesses refuses to answer a question, I'm going to question as best I can, Your Honor.
And you can object, I'm saying, the tone in which you're using. You may continue.
Whether or not the phone is inside or outside,
Yes, sir.
terrain,
Yes, sir.
and these things can affect the reported or the data, correct?
Yes, sir. It can affect the coverage area of the tower.
Okay, thank you. And the accuracy of the distance, correct?
Yes, sir. The distance can sometimes be a little long.
And sometime, earlier you mentioned, the prosecutor, that oftentimes it has corroborated other evidence in a criminal case or an investigation, correct?
Yes, sir.
And so sometimes it doesn't corroborate other evidence, correct?
I'm not sure you understand the question, sir. At that time, it is a mobile phone, so I might say it was here. When we get there, that phone is moved. That's a possibility. But the phone will be in the coverage area of that cell tower.
Well, but earlier you said that often it corroborates other evidence, correct?
Yes, sir.
And then sometimes it's not corroborated by other evidence.
I guess that's a very broad question, sir. I'm not sure exactly what you mean. Do I have a time when I have cell phone data and video putting the subject in an area, the device in an area? No, it is corroborated. But if there's a 20-minute gap, then it might not corroborate that data.
The cell phone tower data shows a certain phone and not a specific person, correct?
No, sir. I make it very clear that I'm talking about a device, not an individual.
Does the accuracy of this technique rely on a direct line of sight signal path to the cell tower?
Not necessarily, sir. The phone will choose the strongest signal with the least amount of interference, generally the closest tower. But if there is a line of sight issue, the phone may choose a farther tower because of the line of sight issue. Yes, sir.
So is that an answer? So that answer is yes?
Yes, sir.
So the answer to my question is, does the accuracy of this technique rely on a direct line of sight signal path to the cell tower? And your answer is yes, correct?
No, sir, because it doesn't have to be a direct line of sight.
Is it true or false that a signal could bounce off a building located a few hundred yards away and still be received by the cell phone?
Yes, sir.
So if the signal bounces off a building several hundred yards away and is received by a cell phone, then the RTT/timing advanced technique would give an quote-unquote incorrect distance. The signal actually travels a longer path.
Yes, sir, it could give, and that's why I've stated that sometimes the RTT time in advance data can be a little long.
So your answer is yes to that, correct?
Yes, sir.
Does your presentation you prepared assume that there is a direct line of sight between the phone and the tower?
No, sir.
If you had to, in your line of work, does your profession or your colleagues, is there an accepted estimate of accuracy on this data?
What do you mean by, I guess I'm asking, the phone will be in the coverage area of the cell tower.
Well, yeah, okay, but what about, for instance, let's use distances. 500 yards, 1,000 yards, give me some examples of some distances.
Sir, it all depends on where you are on the planet. If you're in an urban
Let's
area,
pick North Dallas where all this happened.
yes, sir, towers are generally closer there, so coverage area of the tower would be between half a mile, 3/4 of a mile. If you get in a rural area, that can be a much larger area.
Okay, so these distances that you depicted in your PowerPoint presentation, they range from a short to a long of what, approximately?
I'd have to look through my report, sir, but I have some very short distances, and I have some slightly longer, but the average, and that's all depending on where you are on the planet, but 0.24 miles up to just under 2 miles, depending on which tower it's reading.
Okay, so you say some of them are up to 2 miles, correct?
Yes, sir.
Isn't it true that, for instance, on some of those reports, it could be farther than is depicted by your outer radius half circle?
No, sir, because I'm taking the aggregate of when I get multiple towers giving me time in advance data, I look to where those arcs are crossing, and that's the most likely area where that device could be. If I have a large area of time, this device could be mobile. It could be moving inside that area during that entire time. It is a moment in time when that is depicted.
Did you triangulate, you know what triangulation means?
Yes, sir.
Does this methodology use triangulation?
No, sir.
Tell the court what triangulation means.
Triangulation is basically taking known distance and known direction from several known points. If I was, when I was in the Marines, we use triangulation or back azimuths all the time. The helicopter drops you, and you're supposed to be in this LZ, and you're not in the LZ they're supposed to put you in. So I take it and I go, I know where that mountaintop is on the map. I know where that mountaintop is. I know where that water tower is. I take back azimuths, or I direction from there, take those back azimuths, look where those lines cross, and that gives me, then I can determine roughly where I am.
And using, let's use two.
Sir, can I continue answering the question?
Sure.
So, in what you're asking with the time in advance is the time.
I wasn't, Your Honor, non-responsive. I wasn't asking about time in advance or whatever he's talking about now. I was asking about triangulation.
And if I'm not mistaken, you were asking him to explain to the court what triangulation was, and that is what he was doing. He might have been using other terms, but I think, if I'm not mistaken, that he was trying to.
Your Honor,
look
he
at all
asked
of it.
me if I used triangulation,
Yes,
and then he asked me what triangulation was. I
Yes.
never answered if I used triangulation. I said no, and then I'm trying to explain how the time in advance works. Basically, he asked me two questions. I'm trying to answer those questions.
And
so
Your
the
Honor,
first, hold on. So the first question is, are you done answering what triangulation is?
Yes, ma'am.
All right, now, Mr. Watson, ask your next question.
all right, thank you, Judge.
You're welcome.
So, Agent, isn't it true that using 2 points, which can be used in triangulation, correct,
Yes, sir.
is more accurate than using 1 point, correct?
Yes, sir.
Pass the witness.
Any further questions?
Yes,
Mr.
Judge.
Knight?
Agent Sadler, State Exhibit 320. Would that be helpful to the jury in seeing the graphical representation on a map of Village Mirror cell phone device at certain dates and times compared to the cell phone tower being utilized?
Yes, sir.
Here at this time, State would offer State Exhibit 320 for all purposes.
And Judge,
Yes,
may I show the court the parts that I cross-examined the agent on?
yes.
Are you objecting to certain pages, the entire exhibit?
No,
to
I'm
be
just,
clear?
well, so she can make her decision, I want to show this to her.
So you're objecting to,
I'm objecting to this whole exhibit number 320, but I want to show you what we referenced on the straight lines that we talked about being a blob baseball diamond.
Baseball diamond, yeah.
Correct. And that's included in this report. So page 4, and I'll put this back together for you. Page 7 shows the quote-unquote baseball drawings. Page 8 shows the quote-unquote baseball drawings. Page 9. Page 10. 11. And that's the gist of it, Your Honor. There are many drawings on here. The quote-unquote show the quote-unquote baseball diamond drawings that we submit is not accurate, and we object under relevance, confusion, 403, and it contains evidence, it contains depictions that are not accurate to his report or misstate or mislead the underlying scientific evidence, particularly the portions regarding the direct lines depicted in the quote-unquote baseball diamond drawings. And we object under 403. It's misleading. It gives undue weight to his opinion. He testified, and I believe the court can draw a reference that he can testify as to his findings or beliefs without using this Exhibit 320. It gives undue weight to his opinion, and we object to his opinion in total. And then secondly, we object to 320. We also object it is
not subject to testing for validity. It relies on the subjective interpretation of the expert. It has not been published, and what was not subject to peer review by other experts in the field. It has an unacceptable rate of error. And the question calls for an opinion that is unreliably based. The witness testified that a triangulation method is more accurate than a single point of reference, and that with the different instances that can be longer or further away due to the instances that we talked about when I was questioning him, his report should not be admitted, and secondly, his opinion should not be admitted, and we object to that as for reasons stated before. And his report, aka exhibit, I submit to the court that's more of a prop or an exhibit that is gives undue weight to his testimony, and in some ways you might call it puffing, Judge, and we object to that. And we also object that it violates his due process rights to have certain pieces of evidence given more weight than would normally be given in a jury trial in Texas.
Thank you. You have a response, Mr. Ignatius?
Judge, yes. Exhibit 320 from Agent Sedgwick has stated that it would aid the jury in understanding his testimony. He has discussed his qualifications, his experience and training in using call detail records and time advance records to provide an approximate location. He's also told the court, based upon those records, he's used them in real world. Real world experience itself has proven to him and other agents to be reliable. And he's also stated to the court that during his time reviewing these records and testifying and aiding other agencies, that these records have been corroborated often by other pieces of evidence such as video or witness statements. So he told you about his training from the cell phone carrier himself. He said he's used it in real life, and he said his real life experience sometimes is corroborated by other pieces of evidence. I didn't have an opportunity to go into the specifics of how the cell phone works and what he can tell you about that because the defense counsel took the witness on more dire. He's more than capable of doing that. I plan on doing that. And also with the specifics of the timing advance records, I didn't have an opportunity to go through each page and discuss what he would testify to, or his ultimate opinion would be in regards to the cell phone tower being utilized by the defendant's cell phone device and the approximate location of the cell phone device as to the cell phone tower being utilized. He would provide an estimated distance within an arc, not an X marks the spot, not a specific location, but his testimony would be, as indicated in this report, that the phone is in this approximate location anywhere within this arc, which is X distance from the cell phone tower. And so based upon all that information, and we would ask that this be admitted for all purposes.
Your objection is overruled and 320 will be admitted for all purposes.
Yes, ma'am.
Anything further, Mr. Ignatius?
Person opposed, Judge?
Yes.
Hey, Sedgwick, can you just tell us how a cell phone works?
Yes, sir. When your phone's in your pocket and you're not using it, and it's on, you call that idle mode. And what that phone is doing, in this case, we're dealing with a T-Mobile device. So it's going to look for the strongest signal with the least amount of interference, generally the closest tower, that's a T-Mobile tower. And all cell towers are continuously broadcasting a signal. That's called a control channel. That control channel is always broadcasting. That's the signal the phone's looking for. Once it gets the tower, sees the best, you put you that's camping on that
I
tower.
don't know what we're doing.
It sits on that tower, and while it's camping, there's information being passed to it. The network will tell it, hey, on this tower, hey, these are the other towers in the area you can see, so if I need to hand you off during a call or as you're moving, these are the other towers, the other radio frequencies you should be looking for to make that smooth connection with the network, and you move around, you don't drop a call, or the network works. Time in advance can occur during a call, during a data session when you're surfing the net using cell tower data, or just while it's in idle mode. And what it does is it gives that steering signal, or not steering signal is the wrong term, but it gives it that distance so it knows the signal, and it just creates that time in advance record. Time in advance records, so this sometimes they don't. But that time advance gives that distance, and that distance is the round trip time it takes the signal to get from the tower to the cell phone and back based on the speed of light and vacuum. Obviously, there is going to be obstacles. There's going to be a tree, there's going to be a building, so that signal doesn't travel in that straight line. So that's why I stated sometimes that time advance arc can be a little long. In built-up areas, it can be a little longer. Rural areas, it tends to be more accurate, but it can also be very accurate even in a built-up area. But what I can say is that device had to be short of that time in advance line. But I used time in advance just to possibly narrow down the area where the phone device could be, but it is still in that coverage area of the cell tower, and we use that pie wedge to display that area. The cell signal is not a perfect piece of pie shaped. It is a undulating line. There is overlap between towers. There's overlap between sectors in the tower, so they have that multiple coverage so you can see. And there are ways we have equipment that we call the drive test, where I can take equipment and map the actual RF footprint of the cell tower. In this case, I was not able to do that because I was brought into this case in October of this year. This happened back in 2018. The network is not the same. So a drive test would not depict what was in the real world at that time.
And Agent Semick, I don't mean to cut you off, but ultimately the timing advance records and the were utilized into interpreting and ultimately plotting and mapping the defendant's cell phone device. Is that right?
Yes, sir.
Okay, and the exhibit that was just submitted said Exhibit 320 would show the representations based upon the information you just relayed to the judge.
Yes, sir.
And Judge, just for purposes of the record, in regards to State's Exhibit number 320,
Yes.
obviously you heard and we noted our objections for the record, and you've overruled those objections. Is that correct?
Yes.
And so Agent said we will be able to testify as to his findings as well as display the report to the jury over our objections. Is that correct, John?
Yes.
Okay, for the purpose of this hearing and the record, we're good.
Okay.
We can move forward, John.
All right, so there was a 319 and a 320. Right now, we only discuss 320.
Correct, Judge. I have an additional witness, I think, that
Okay.
will testify to the contents of 319.
All right. So can we excuse this witness?
For this time, yes, Judge.
All right. So you are excused temporarily
Yes, Your Honor.
What can we-
until you be recalled.
Yes, ma'am.
Thank you. Do we have any other witnesses for 702, 705 here?
I think that's it, Judge.
Who do you want? Oh, no, we're good, John. We're
All
good.
right.
Take off William Noble off the witnesses that we call.
Okay. So are y'all ready to call your first witness?
We're ready to call, yes.
I think
That's not going to be set.
No.
Mr. Ivy's missing, so,
He's going to go get.
okay. Deputy White, you want to go get the jurors lined up? Well, good morning, everyone. As y'all can see, the temperature is a little different in here today. So yesterday we were on a sauna, today it's a little cooler. So you're welcome to bring in your coats, your jackets, if you have a blanket, you're welcome to do that. As you know, we are back on the record in cause number F1875401, which is the state of Texas versus Billy Shamirmir. Where we ended yesterday was the state of Texas was still presenting their case in chief, and we will allow that to continue today. Mr. Fitzmartin, you may call your next witness.
Thank you, Judge. We'll call Jalad Nizanov.
Good morning.
Morning.
Yes, you may testify with or without your mask, whatever makes you feel comfortable, okay?
Yes.
All right, will you please raise your right hand for me? Do you so solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, thank you so much. Mr. Fitzmartin?
Thank you, Judge. Can you please state your name and spell your first and last name?
Gilad Nisanov, Gilad Nissanov.
And how are you employed?
I work at Diamond and Gold Exchange,
Are you one of the owners there at Diamond and Gold
like
Exchange?
managing partners. Yeah.
And what is Diamond and Gold Exchange?
So we buy and sell jewelry, precious metals, coins, items of that nature.
And where are you located?
In North Dallas on 635 in Court Road.
So, there's a shopping center there at 635 McCoy.
Yes, sir.
And in the shopping center, what other stores are there in that shopping center?
There's Starbucks, coffee. There was a cleaners at one point. There's a beauty school. There's
Is there a Metro PCS? Was there?
yeah, there's a Metro, and there's a Subway as well.
And how long have y'all been in that location?
Since 2010.
And tell me, how does your business work there, as far as people coming and going and buying and selling from the public?
Okay. So people come in and they bring in items for us to go over and assess. And we go over the items and then we make an offer on the items.
And how do you know what offer to make?
With appraisers on site, we go over various items just based on expertise more than anything.
Okay, and you rely on what you've done in the past to evaluate jewelry, evaluate precious stones, metals, that and whatnot.
Correct, yeah.
And then the amount that you give out, are you hoping to then flip that and make more money on the sale of that down the road?
Yeah, of course,
That's your business model, right?
right.
Yeah, okay. Back in, starting in 2015 and going up into 2018, did you do business with an individual by the name of Billy Shamirmir?
Yes,
Okay, I'm gonna ask you to look around the courtroom and see if you see anyone in here that looks similar to, or is, you see Mr. Shamirmir.
Can you take his mask off? That's him?
That's, the man who just took his mask off, that's Billy Shamirmir?
Yeah.
All right, let the record reflect the witness has identified the defendant in open court.
All right, the witness, the record will so reflect that the witness identified the defendant in open court.
At some point in time, did the police agencies come and visit with you regarding Mr. Shamirmir and his dealings with you?
That is correct.
And did you provide records to the police department?
I did.
We'll show you State's Exhibit number 286. When someone comes in to to buy and sell, do you try to get IDs from them?
We have to come on.
Okay. And so 286, is this a collection of the IDs that were given to you by Village of Humor over the transactions that you all have done with it?
Yes, these are.
287, do you all keep receipts of transactions that you do with Mr. Tremere
Yes, we
and with everybody else?
do. Everybody.
And as 287, so we get about 34 pages. Sometimes there's 2 receipts to a page of transactions between your establishment and Village of Humor.
Correct.
288, is this a summary of what's contained in State's Exhibit 287, showing and translating some of, is this your handwriting, or is your brother also another partner there?
Yeah, some of it is my handwriting, yes.
Okay, but you identify all that, you can identify all that handwriting.
Yeah, of course.
And then is this kind of a summary of that, showing what your handwriting lays out and the amounts that were sold or bought from Mr. Tremere?
Yeah, yeah.
289, they also ask you to try to pull any surveillance video. You have surveillance video in your store. Did they ask you to pull surveillance videos of transactions with Mr. Tremere?
Yeah.
And did you, were you able to find 3 transactions on March 19th? Or not 3 transactions, but 3 clips of Mr. Tremere on March 19th?
Yeah.
And did you email those clips to the Plano Police Department, and 289, the emails that you sent those clips in?
Yes.
State's Exhibit number 290, are these the 3 clips that are discussed in State's Exhibit 289, dealing with March 19th and showing Mr. Tremere in your store?
Yes.
And then State's Exhibit 291, is this a still shot from one of those videos of Mr. Tremere at about 101 on March 19th?
Yeah, that is.
Judge, at this time, we will offer State's Exhibits 286 to 291.
Your Honor, the defense would object to State's Exhibits 287 and 288. 287 are the, copies of invoices or receipts alleged to be between Diamond Gold Exchange and Mr. Tremere. And 288 is basically a list of those same transactions. And Judge, we would object to the relevance of those, any of those that are not tied directly to Mr. Tremere and the issues in front of this jury. So our objection would be relevance as well as a 403 objection, that their probative value is outweighed by the prejudicial effect on Mr. Tremere Johnson. And we don't have any objections to 286, 291, and 289. Where this one was? And 290, to be honest.
So can I see 286? This is 288. State, do you have a response?
Judge, these are the transactions that Mr. Tremere made with this establishment. I think it is relevant. He did state, as we played in his statement, that he buys and sells jewelry, and this shows the the sellings that he was doing at the Diamond and Gold Exchange. I think it is relevant. It's business records. They've been on file, or the defense has had these for over 14 days before the date of trial.
All right, so exhibits 288 and 287 will be admitted along with 286, 289, and 290 and 291.
You guys permission to publish?
You may.
All right, so 289, or 286, what we're looking at here, these are some of the IDs that you took from Mr. Chimera when he's making transactions, is that right?
Yes.
And you would keep those for your records so that you can establish when you buy stuff from an individual.
Correct.
Looking at State's Exhibit 287, this is a packet that's from page 1 to page 34. And when we look at this, we can see that you're going to list off who the customer is, and his address and his phone number there, that 972-674-7527, right?
Yes.
And then you have, you write in here, what are you writing in here?
These are the different items. 925 is sterling, and 750 is 18 karat, and then silverware platters as well.
All right, and then the amount that you're paying him that amount, $1,000 at that time.
Yes.
And then you have a date there, looks like November 23rd of 2015.
Yes.
And then each one of these is that same scenario of his name, the item, the amount. Is that right?
Yes.
And the date. You can go through this to see all of those different transactions, correct?
Yes.
Now, at some point in time, because that handwriting, you know what it says, but maybe not everybody else does, right?
All right.
Okay. And so, State's Exhibit 288. Have we summarized, you just said 925 meant something to you, and then it says it's sterling silver, 92.5 pure silver,
Yes.
okay? And so, you had 750 here, and then there's a translation of that, 750, 18 karat gold, white or yellow.
Yes.
So this 288 is basically a summary of everything that's happening in 287.
Yes.
And so it lists off, we just talked about November 23rd, that there was 925, 18 karat silverware and platters for $1,000.
Yes.
So these list off all of the transactions that Mr. Chimera was making with your establishment, starting in 2015. All the way down to March 19th of 2018.
Yes.
And the total of the amount that you all sold to him was, in that time span, is $91,300, or you bought from him, it was $91,350.
Yes.
On page 27 of this, of the 287, are there two transactions? One on January 30th, you see that?
Yes.
And then one on January 31st.
Yes.
at January 30th, there was a transaction for 14 karat with diamonds for $2,150.
Yes.
On January 31st, 14 karat, 18 karat diamonds for $3,050.
Yes.
On March 19th, there was a purchase for $105.
Yes.
Now these last dates here, March 1st, 2nd, 4th, 9th, they also have the hours that these things were sold. You see that?
Yes.
Now you could get video of him at your store during those hours. But those other, prior to that, you don't know what time he actually came in because you didn't keep those records
The video doesn't keep
for that far back. So what I'm saying is if we're to rely on what's in 287, your invoices, you don't write down the time on there. You just write down the date.
Correct.
So 2 sales were made at your store. You're purchasing them, right? But he's selling it.
Right.
Is that fair to say? And then even going beyond that, if we look at February 8th, February 14th, there's other gold, other things being sold to you as well.
Yes.
$289. These are the emails that you sent to the Plano Police Department, in this case, to Detective Hoffman. You remember meeting with Detective Hoffman about this?
Yeah.
And each one of these clips has a unique number. It's 152, 1480, this long number, that's a unique number for each clip. And so this first page of 289 deals with this clip. So there's a clip that ends in 3984, 4739, and 1864. Do you see that?
Yeah.
And then the different times. So 319 at 1236, 319 at 1256, and 319 at 101. We see here in 282 in State's Exhibit 291, 319 at 101, is that Mr. Chamir sitting in the chair?
Yes.
So we can see the clip number on there is 1521 with ending in 1864. And do you see Mr. Chamir there in your store? Looks like he's using his phone or on his phone.
Yeah.
He used to be dressed in a jacket, blue shirt. Was he always kind of well dressed when he came into you?
Yeah, sometimes dressed in a suit.
What else would he wear?
Sometimes it's like
You can pull that microphone a little closer, get a little closer.
sometimes like scrubs as well.
Okay. Is this him at another time on that same day collecting money from you?
Yes.
And that was clip number 4739. And then here's your last clip. Is that what you remember walking in?
Yes.
So, and that's for clip 3984. So, people don't, thank you, Judge. People don't have to make appointments to come see you, right? They just walk in and you service them right there at that point.
Right.
So we know that on 3/19, that day, he made a sale to you all we can see you got $105.
Yeah.
So you show them there on 3/19,
Yes.
making that sale to you.
Yes.
And your story says the Diamond Gold Exchange is on the corner of basically Coit and 635.
Yes.
And then on January 30th, you made two sales, on the 30th and 31st, you made those two sales to you as well. I'll pass on this.
Mr. Warren, any questions?
Yes, Your Honor, thank you. Good morning, is it Nisanov? Am I saying that correctly?
That's right.
Good morning, how are you?
Good morning.
My name is Kobe Warren, I represent Mr. Shamir in these proceedings, Mr. Nisanov, I just have a few questions for you, okay?
Yes, sir.
I believe you stated with Mr. Fitzmartin that you've been in this business with the Diamond Gold Exchange with you and your brother and I guess a few other partners, is that correct?
Yeah.
Is that since 2010 or since when?
2008.
2008? And then has it always been at this location that we've been discussing here this morning?
No.
Okay, where was the prior location?
We have other locations.
Okay, how many total?
3 locations.
Okay. 2 locations, for approximately 13 years you guys have been in this business, is that correct?
Correct.
And during those 13 years, I guess it's fair to say that you have some customers that will come in on a one-time basis and sell some precious metals or jewelry to you, is that right?
Correct.
And then I'm sure you have some customers that you've had for several years, is that right?
Correct.
Do you have any customers to this day, Mr. Nisanov, that you've had since you've opened?
Possibly so, but it's hard to remember exactly.
Okay. I mean, so, but there's nothing odd about a person coming in and on a regular basis selling you jewelry or precious metals, is that correct?
That's correct.
Like, that's not out of the ordinary, that happens all the time in your line of business, right?
Correct.
Actually, it's better for you, isn't it?
It's better for us, but it happens, it does happen.
Right. That's all I have. Thank you, Mr. Ms. Knox.
Yeah.
Anything further?
Nothing further, Judge.
All right, may this witness be released?
Yes, Judge.
No objection, John.
All right, you are free to go. Thank you so much. State, you may call your next witness.
Yes, Judge, they would call Michael Pasillo.
All right. Good morning.
Morning, ma'am.
Will you please raise your right hand for me? Do you so solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. You can have a
Thank
seat
you.
for me. And you are welcome to testify with or without your mask, whichever you feel comfortable with.
Without.
Okay, thank you. You may continue. Make your announcements.
Thank you, Judge. Good morning, Mr. Pasillo.
Good morning, sir.
How are you doing?
I'm doing pretty good. How
Can
about
you move
you?
that microphone, Mr. Ignacio, so we can hear you? Yeah. That's probably good.
All right, Mr. Pasillo, will you please state your first and last name and spell both for the court?
Yeah, Michael, M-I-C-H-A-E-L, Bosillo, B-O-S-I-L-L-O.
And Mr. Pasillo, how are you currently employed?
I'm employed with T-Mobile Cell Phone Company located out of Frisco, Texas.
And how long have you worked for T-Mobile?
Going on 10 years.
I guess where are you currently assigned within T-Mobile?
I'm assigned as a testifier, and I work basically out of my home, but I travel 2 to 3 times a week.
Testifier, do you mean kind of a custodian of records for T-Mobile?
Yeah, custodian of records testifier, and what that is, we just primarily are trained to help explain and interpret the records to the court and to the jury if they have any questions about them. We aren't, those of us who are in the unit, the trial unit, we aren't engineers, but we have a good working understanding of how all this works between the handstand, the tower, and the switch.
So for those 10 years that you've been working for T-Mobile, has it always been in this position?
Yes.
And you said you travel within Texas or multiple other states. Where exactly do you travel to?
All for, what do you call it, contiguous, 48 states. The only states that I don't travel to are Hawaii and Alaska, because the supervisors get those assigned.
In your capacity as the testifier or custodian of records, have you become familiar with the cell phone records that are regularly kept in the ordinary course of business for T-Mobile?
I am.
And do those records include what we refer to as call detail records, timing advance records, and also subscriber information?
That's correct.
Is it common for law enforcement to make requests for these types of records that T-Mobile maintains for their business purpose?
It is.
And you're aware that law enforcement uses them for a different purpose than what T-Mobile does?
That's correct.
Your man versus witness?
You may.
Mr. Pasillo, I'm showing you what's been marked as State Exhibit 319. Do you recognize this?
I did.
And how do you recognize this?
I recognize this as a disc containing records we provided based on the legal demand that was made pursuant to that phone number.
And so legal demand, a search warrant was requested for cell phone records of 972-674-7528.
It was.
Okay. And the result of that search warrant would be the records received, is that right?
That's correct.
Okay. And State Exhibit 319, are you telling the members of the jury that that contains those records that you told us T-Mobile maintains in the ordinary course of business?
It does.
And that would include the call detail records,
Yes, sir.
the timing advance records,
Yes, sir.
and the subscriber information.
Correct.
And these are records that are regularly conducted business activity by T-Mobile.
They are, sir.
And were these records made at or near the time of the occurrence?
Yes, sir.
And T-Mobile maintains these records. Would you agree for efficiency, maintaining the network and identifying what areas potentially need work or more cell phone towers?
It does. We try to make a perfect product.
And that would be the purpose of T-Mobile maintaining these. However, you know that law enforcement uses them to approximate the location of a cell phone device.
I do.
And would you agree that maybe an expert would be in a better position to interpret the call detail records than the timing advance records?
I missed the first part of that question.
I'm sorry, would you agree with me that an expert whose role and responsibility is to interpret these and approximate a location would be better served doing that as opposed to you?
Correct.
And so you really are able to say that T-Mobile maintains these records and keeps them and maintains them during the ordinary course of business.
That's correct.
Your Honor, at this time, State would offer State Exhibit 319 for all purposes.
No objection, Your Honor.
All right, State Exhibit number 319 will be admitted.
Your Honor, you pass the witness.
Mr. Warren, any questions?
No questions this time, Your Honor.
All right, may this witness be excused.
No objection.
We'll have him on standby for you, Your Honor.
All right. So, Mr. Basilio, as you know how this works, we're gonna excuse you, but you'll be on standby. Just make sure that all the parties have your good contact number. So just in case either side wants to call you back, you're available, okay?
Yes, ma'am.
Thank you.
Thank you.
State, you may call your next witness.
Thank you, Judge. State would call Mark Sedgwick.
You can be seated. And Agent Sedgwick, you have been sworn in previously for a hearing outside the presence of the jury. You are still that same witness that was sworn in previously at approximately 8:33 p.m., 8:15 a.m. this morning, correct?
Yes, Your Honor.
And you are still under that oath. You understand that?
Yes, Your Honor, I do.
All right. You may proceed, Mr. Hernandez.
Thank you, Judge. Good morning, Agent Sedgwick.
Morning.
How are you doing?
Good.
Okay, will you please introduce yourself to the members of the jury?
My name is Mark Sedgwick, and I'm a special agent with the Federal Bureau of Investigation out of the Dallas office.
And how long have you been a special agent with the FBI?
23 years.
Prior to that position, can you tell us a little bit about yourself?
I was a 1993 graduate of the United States Naval Academy and served in the Marines as an artillery officer for 5 years, and then came to the Bureau.
And since being at the FBI, what positions have you held?
I've been a special agent the entire time, working mostly narcotics and violent crime with small stints in counterterrorism and public corruption. But currently, I'm a member of the Cellular Analysis Survey Team, or the CAS team.
And can you tell the jury a little bit about what the CAS team does and who they are?
The CAS team is a group of specially trained agents and task force officers who have been certified as experts in the analysis of call detail records, or CDRs.
And the jury just heard from Mike DeCello, custodian of T-Mobile. He told them about call detail records and timing advance records. Are these the type of records that you're describing as being reviewed by the CAS team?
Yes, sir.
As far as it relates to criminal investigations, what does the CAS team do?
The CAS team was brought into existence to assist the FBI, other federal agencies, and local and state agencies in the analysis of call detail records. That's basically using those records to place a device in a certain area. I can determine off of the call detail records that a cell phone utilized a certain tower and sector of the tower and had to be in the coverage area of that tower when that call or text, or in the case of time in advance, was created.
So I think what you're telling us is you're able to give an approximate location of a cell phone device based upon these records.
Yes, sir.
Now, to be able to do something like this, what kind of specialized training and experience do you have?
I've had over 400 hours of initial training in the analysis. That includes from other FBI agents, outside companies on how radio frequency works. A cell phone is basically a two-way radio, and it communicates to the cell towers through radio frequency or RF. So I took classes on how RF works, but most importantly, I've been trained by the engineers from all the major service providers in the United States, AT&T, T-Mobile, Verizon, on how the network works, how a cell phone works, and how that cell phone interacts with the network.
And how long have you been doing this as part of the CAS team?
I took my first intro to it back in 2007 and became fully certified in 2014. CAS came into existence in 2012.
And is this something that only the Dallas office is doing, or is this type of analysis recognized across the United States?
The CAS unit is out of headquarters in Washington, D.C., and we have agents throughout majority of the field offices.
And can you kind of just give an idea of how many times you yourself have reviewed these type of records and give an approximate location of a cell phone device?
I've reviewed thousands of records.
And Agent Sedgwick talked about your experience and training with the mobile phone carriers, Sprint, T-Mobile. Is it a big four now?
Big three, AT&T, T-Mobile, and Verizon. T-Mobile recently purchased Sprint, so they're in the process of shutting down the Sprint network.
Do you believe, in your opinion, that your analysis of cell phone location information to be reliable?
Yes, sir.
And what do you base that on?
I base it on my real-world experience. I have, based on all my training I've received, I have the detailed knowledge of how to read the call detail records and other records from all the different providers. I have detailed knowledge of how a cell phone works, how the network works, and how that cell phone interacts with the cell network. But thirdly, and most importantly, is I have the real-world experience in real time of using these call details records to locate a kidnapped victim, to locate a fugitive, to find that missing person, to sometimes unfortunately find that body.
So what you're saying is there are times where you actually interpret these records similar to State Exhibit 319 and assist in an ongoing investigation of possibly a missing person,
Yes, sir.
or helping, assisting, apprehending a suspect.
Yes, sir.
And your analysis, you're telling us, has actually located or assisted in providing an approximate location where that person was.
Yes, sir.
Is this something you've done just once, twice, or is it often done by yourself?
I've done it probably, I've worked several kidnappings. Since COVID started, I've probably worked 20 or 30 kidnappings in the last couple of years. I've found several fugitives and other missing persons, and the CAS unit does it almost daily.
I was going to ask, is this something that Agent Mark Sedgwick does alone, or is it something that also the other team members within the CAS are successful as well?
Yes, sir. We do this throughout the country and international.
In addition to finding these reliable from the ongoing investigation, are there times where you review records, get a conclusion, and then later find out that there is corroborating evidence, such as video or witness statements to corroborate the location that you provided?
Yes, sir.
So you mentioned that a cell phone is you said a two-way radio?
Yes, sir.
What do you mean by that?
Well, basically, if any of your kids are from the military and you were using military radio, that's a one-way radio. You press a button to talk, and then to be able to hear, you have to release that button. Basically, a cell phone is a two-way radio, so both sides can talk to each other at the same time. You can talk over someone on a cell phone conversation, but it is a radio, it's radio transmissions to the cell tower.
And so, cell tower, can you tell the jury what exactly a cell tower is?
Cell tower, I think most people have seen them on the side of the road. They generally in the United States are broken up into 3 sectors or pieces of pie to give that coverage area in that circle. And then basically by taking the call detail records, what those call detail records give me is the date and time of a call, the 2 numbers that were involved, incoming, outgoing, length of the call. But it also gives me the tower and sector or side of the tower that was utilized for that call. Based on that and knowing where all the other towers for T-Mobile, in this case, are at that time, I can then determine the approximate location that device had to be at the time of that call or text.
So, going back a little bit into just general how a cell phone is able to work. Cell phone right here, is it necessary for a cell tower to be utilized to have a connection?
Yes, sir. The way your phone works is when it's in idle mode or sitting in your pocket and you're not actively in a call or a text or a data session, that cell phone is looking for the strongest signal with the least amount of interference, generally the closest tower. And it's going to what we refer to as camp on that tower.
Yeah, I don't mean to cut you off, but I wanted to ask, so a cell phone tower is what gives that signal?
Yes, sir. All cell towers are continuously broadcasting the signal, called referred to as a control channel, that's constantly broadcast. That's what that cell phone is looking for, that RF signal from that cell tower. And then once it identifies the tower it sees as the best signal, it'll what we refer to as camp on that tower. It just, I like this tower, I'm going to stay on this tower. That control channel also provides some information to the phone. The biggest thing it provides is what we refer to as a neighbor list. That neighbor list is the other towers or sectors of towers in the area that phone should be able to see, because there's a built-in overlap in the network. So it's like you can see tower A, side 1, you're on tower B, side 3, or you can also see tower C, side 2, depending on how the network's set up. So while you're in a call, if there needs to be a handoff or you're moving, that transition is very smooth and it's unnoticeable to the end user.
And I guess that kind of takes me into the placement of cell phone towers. Is it just that cities have 1, 5, 10? And does it depend on the type of location for the amount of cell phone towers?
Yes, the more population, the more customers they have in an area, the more cellular towers they have to provide that service. So in an urban area, Dallas, Fort Worth area, towers can be a couple blocks apart in downtown areas. As you start to get more to more rural areas, cell towers can be 5, maybe 10 miles apart because they don't have as many customers in the area, so they don't need as much towers and that RF to provide the service to those customers.
So, cell towers give a signal, and our cell phones, when they are on, are looking for that strongest signal. Is that right?
Yes, sir.
And the strongest signal, what is the general principle of where that cell phone tower would be?
Generally, it'll be your closest tower, but there is some line of sight issues. So if I have a cell phone and there's a tower that's closer, but there's like a building in between, but I have a direct line of sight to a slightly farther tower, my phone might see that farther tower as a stronger signal because the building's in the way. The other signal from their tower will go around that building and be usable, but it might be stronger from another tower. But what I can state is that the phone had to be, when a call or text was made, had to be in the coverage area of that tower. I can't narrow it down any more than that. In this case, I have what's referred to as time in advance records, where they not only give me the cell tower and sector, but they also give me the approximate distance that that phone was from a cell tower, so it can be anywhere within that distance arc.
And I'm gonna talk about the time in advance records you're just referring to. But you mentioned the coverage area of the tower. And you told us the differences between a rural versus an urban area, or, you know. So I guess as far as the coverage area, does that change depending on the environment and the area of the cell phone tower?
Yes, sir.
Could you explain that a little bit? I guess if this was Dallas compared to, you know, maybe a country area.
As I stated, the cell towers in an urban area will be much closer together because there are more phones, so they have to have more towers to provide that coverage. When you get out to rural areas, there are not as many people, there are not as many devices, so they don't have to put up as many towers to provide that coverage. Cell towers are expensive to put up. The engineers, they pay engineers a lot of money to look at and design and predict what coverage they're going to need, but they're not going to just put up a new tower with no reason. They want to put up so they provide that good coverage, but are using the least amount of resources because they are a for-profit company.
So would it be fair to say that we use Dallas, so if you were mapping a cell phone utilizing downtown Dallas towers, you'd be able to provide a more narrow approximation because that cell tower would have a smaller range of coverage.
Yes, sir.
Did I say that right?
Yes, sir.
Okay. Whereas somewhere else, East Texas, that range of coverage of that cell phone tower would be a lot larger.
Yes, sir.
And that would be because of, I guess, the load or the amount of customers or the need for cell phone towers in the area.
Yes, sir. It's based on the need in the area.
I'm going to go back to where you said what our cell phones are doing when they're just sitting in idle mode. Why are they searching for that strongest signal, which you said most often is the closest cell phone tower, but what's the purpose of that happening?
Well, that's so, since you're on the control channel, when you go to make a call or surf data or whatever, but when you hit send on your phone, it sends a signal to the tower that it was camped on, and there's an authentication, you're a T-Mobile customer, you pay the bill, okay, you can use the network. That's the cell tower sector that will be recorded in the call detail records. So as you get into a call, your cell phone is in charge. It chooses the best tower that it sees at that moment. For an incoming call or text, the network doesn't keep track of where the phone is camped. It doesn't know that I'm camped on a particular tower. It knows I'm in downtown Dallas, has a general idea where I am. The network does. So when I get an incoming call, they'll just send a page out of all those towers in the area, and I'll respond on the tower to the tower that I see the best. So on an incoming call or text, it is still the phone choosing the tower that is reflected in the call detail records.
And correct me if I'm wrong, so pretty much a phone that's not currently in use is monitoring these cell phone towers because to pick up a phone and make a call, it needs to be ready. Is that right?
Yes, sir. And best kind of way to think about that is when you get on a plane, you get off your plane, your plane lands, and they say turn your cell phone on. And the first thing everyone does is turn your cell phone back on. And you look at it and you see, hey, I got my bars and everything. You look at it, and then maybe 10, 15 seconds later, you get that dump of the 5 missed calls and the 4 texts you missed during the thing. What it's saying is, okay, hey, it's reading the environment. It knows their T-Mobile tower, but until it makes that connection and goes, that's my best tower, and connects to it, then you get that dump of the missed data. That's kind of the way it works.
And the lag time where the phone is looking out for the strongest signal, are there records that reflect some of that information?
That's what we refer to as the time in advance. What time in advance is it basically time in advance measures how long it took the signal to get from the cell tower to the phone and back. And then, so they know that how long it took, and then that's computed at the speed of light in a vacuum, so then they can approximate how far away from the cell phone tower that device was. And time in advance does not have to be associated with a particular call or a text or a data session. Sometimes time in advance can be created in the background while that phone is in idle mode.
And I don't know, basically, you're not making an incoming or outgoing call or texting. These, I call them time advance records, could still be produced by T-Mobile.
Yes, most of the time you're probably involved in a data session. There's some app or something running in the background of your phone, but it is in the background. It doesn't have to be associated with a call or a text.
And the type of information that are contained within the time advance records, you mentioned that the calculation of the time from the cell phone communicating to a tower and back. Is that included in the time advance records?
The time advance basically takes how long it took a signal to get from the cell tower to the cell phone and then back, that round trip, and then basically divided by 2, that's the time. Knowing how fast that signal can travel gives that distance that phone could be from that cell tower.
And those records that are contained within 319, they provide that information?
Yes, sir.
It's provided in the form of an actual distance, right?
Yes, sir. It'll give the cell tower side of the cell tower and the date and time, the cell tower side of the cell tower, and then the distance from that tower.
And the distance, is that an approximation?
Yes, sir. There is about a 100-meter level of uncertainty, basically because that's how far that signal can travel in between the timestamps that it's allowed to that it can read. That's how fast that signal's traveling. And then time in advance, since it's computed in a vacuum, obviously we're not in a vacuum, so time in advance can sometimes be a little long. It can be a little long because it assumed the signal didn't have to go around the building or change, divert at all when it computes that distance. So time in advance sometimes can be a little long, but it still gives me that general distance from that tower. It narrows down where in that sector that phone could be.
And what other variables or factors could affect that time distance?
It's basically is just, building topography, stuff like that could affect that time in advance distance.
And is that part of the reason why this is an approximation and not a X marks the spot?
Yes, sir. And even if it wasn't a vacuum, I could only still say it was in that arc. During my presentation, you'll see the repetition arcs. It could be anywhere within that arc. As I stated, with just a telephone call, I can only say the phone was somewhere in the coverage area of that cell tower. I can't specifically say a phone was at 123 Smith Street. I can say it utilized a tower that has a coverage area that includes 123 Smith Street.
And so that's time in advance records. Now, if you make a call or receive a call, the type of records that are produced are called what?
Call detail records or CDRs.
Okay. And do those include this distance that you're referring to from the cell phone tower?
No, sir. They just give me the date and time of the call or text, the 2 numbers involved, and then the cell tower and sector of that the phone utilized for that call or text.
So, is it fair to say, I kind of call it the CDR plus is time in advance. It gives you the cell phone tower, the sector, but also gives you that estimated distance from the cell phone tower.
Yes, sir.
Are there times where a time in advance record could capture a call detail record?
There are times when a time in advance record could be associated with a call, like it happened during, looking back and say, yes, there was a telephone call going on at that time. So it can be associated, but it's independent record.
And so you would be able to say it's consistent. The records from the call detail records, that tower and that sector, you would expect to be the exact same as the tower and sector in the time in advance record.
Yes, sir. Sometimes you can grab in time in advance. You might get one of the neighboring towers, so you can have a neighboring tower also provide a time in advance record, but generally it'll be the same tower. It generally tends to be the dominant tower.
showing you what's been marked indicated as Exhibit 3.
Yes, sir, that is a disk containing the records I utilized for my analysis.
Okay. And do they pertain to a cell phone number 972-674-7527?
Yes, sir, they do.
And you talked to us and explained all detailed records and time advance records. Are those records contained within State Exhibit 319?
Yes, sir, they are.
Now, State Exhibit 320, which has already been admitted into evidence, do you recognize this?
Yes, sir.
And what exactly are we looking at here, without getting into too much detail?
That's basically the report I prepared. It shows on maps the cell towers utilized utilized by the phone in my analysis of the approximate location of the device during working times.
And oftentimes requests for cell phone records are voluminous, would you agree?
Yes, sir.
Okay, so is it common to be asked to interpret, to review, to analyze specific dates?
Yes, sir.
In this particular case, were you asked to review January 30th, 2018?
Yes, sir, I was.
January 31st, 2018?
Yes, sir, I was.
March 15th, 2018?
Yes, sir.
March 19th, 2018?
Yes, sir.
And March 20th, 2018?
Yes, sir.
Okay. The records that we had, were there time advance records for every one of those dates?
There were, except for March 20th.
And do you know the reason for that? If you don't,
I don't know if they just, I got pulled into this case in October of this year, and I was provided the records. I don't know why there was no time advance for the 20th.
I guess based on your experience, are you aware that oftentimes time advance records only last a certain amount of time? If they're not requested, they're gone.
Yes, sir.
And State Exhibit 320, which is your report, does it include maps of locations of interest that you were asked to compare to Village Junior cell phone?
I was provided that cellular number, and I was told that that phone was associated with the defendant. When I'm testifying, I am talking about the device, the cell phone itself. I can't state who was using that phone, who was carrying the phone at any time during my analysis.
Your permission to publish the Exhibit 320?
You may.
So look, I'm looking at page 2 of your report. The jury's already heard a little bit. Thank you. Sorry about that. Can you explain to the jury what page 2 is?
Basically, this is the written report. I was basically asked by the DA's office to look at the records for this number. The methodology is I take those call detail records, and then I take the contemporaneous tower list that exists, the towers that existed at that time. This happened back in 2018. I looked at this in 2021. I wouldn't want to use the cell towers that are in existence today. I want to use the towers that were in existence back in 2018. I then take mapping software and I will map all the towers, the location of all the cell towers, and then I map the specific usage tower and sector when there were calls or time in advance records, and then show those in the maps to give a visual representation of the approximate area the device had to be when that call or text or time in advance event occurred.
And page 3, we talked a little bit about cell phone towers. You mentioned sectors, but for the jury to understand, can you tell us a little about what we see here?
Yes, sir. What on the left hand side of the slide, that is a macro tower. That is kind of the cell tower you see on the side of the road. But if you notice from the aerial view just below it, there are 3 distinct sides to that cell tower. So those cell towers are designed to point in a specific direction. And in the CDRs and the tower list, I'm given not only the cell tower, but the side of the cell tower. And in that tower list, I'll be given the orientation or azimuth that that cell tower is pointing at, that side. I'm given the center azimuth. So in this example that I have to the right, If I'm given a, sector 1 is oriented or has an azimuth of 60 degrees, that cell tower covers approximately 60 degrees to either side of that center azimuth. So it'll cover basically 120 degree, a little more than 120 degree coverage area because of the built-in overlap of the network. Sectors overlap, cell towers themselves overlap. But to think of it on a clock face, because most people don't think compass, if I'm given 60 degrees, that's equivalent to 2 o'clock on a clock face. Every 30 degrees is equal to an hour on a clock face. So if I'm given a tower that's oriented at 60 degrees, its coverage area is approximately from 12 o'clock to 4 o'clock on a clock face.
So the sectors that are contained within your call detail records or timing advance records, how do they assist, I guess, in approximating a location of a cell phone?
Because if I was just given the cell tower, I would have a 360-degree circle. So I'd have to say it was somewhere within the circle. By it being sectorized, I can narrow that, and the majority of cell towers in the United States are broken up into 3 sectors. So I can narrow it down to approximately the 1/3 of that circle.
And just to show right here, what I'm outlining here are in the darker blue. Would that be an example of a sector?
Yes, sir. And obviously a sector, our radio frequency is not going to travel in a perfectly straight line. There's not going to be straight lines of this coverage area. We just use, if you go to the next slide,
Page 4.
we use, to the far left, that symbol of kind of that piece of pie wedge to represent that proximate coverage area of that cell tower. The 2 sector arms off to the side, in this example, this tower is oriented north, 0 degrees, so that tower is covering 60 degrees to either side. And then that shaded area at the bottom is just to show the emphasis of how the RF energy is going out from the cell tower. The easiest way to think of it is it kind of goes out in an upside down funnel shape. So it goes out, but it's not going to be these perfectly straight lines. And I can only approximate where a cell tower ends based on the training I've received and knowing the overlap that exists in the tower and the network. I can say, the tower approximate coverage area ends here, but I can't say like, yes, this tower stops, the coverage area of this tower stops here, unless I do further testing, which in this case I could not do because over 3 years had passed since the records were created and the network would not be the same.
So this cell phone tower is 360 degrees, and the sector would be typically 120 degree area, and you're able to narrow down where the cell phone approximation is by knowing that sector.
Yes, sir. And then in the case of time in advance, then I'll have the distance. If you look to in the middle, what I have is basically I'll have that same shaded area, but then I have kind of like the hot dog or the wedge, and that shows that approximate distance that cell phone was from that tower for that time in advance record.
And just to go back to the timing advance is the calculation from the cell phone communicating to a tower and back to the cell phone.
No, sir. The tower communicating the cell phone and then back to the tower.
Okay. And that then is calculated by the speed of light, and ultimately a distance is provided.
Yes, sir.
And you are able to take the tower and the sector, and then take that distance from those records and give an estimated location or approximate the cell phone device. Is that right?
Yes, sir. What I can say is the phone will be somewhere within that hot dog or closer to the cell tower, because as I stated, sometimes the time advance distance can be a little long. The phone might be short of that time advance depending on the factors I talked about earlier.
And before we start looking at specific dates and your maps, this box, is this something that we're going to see to describe the actual, I'll call it an event or record that we're reviewing?
Yes, sir. I'll have pieces of the pie wedges and the arcs representing the time advance and the calls. But what we have is the CID or cell ID, and that's unique within the network. So tower 77311 exists in one place on the planet. And then that's sector 1-2. And then you have the date of the call. You have then the first thing is the number that the records were for, the date, or excuse me, the time of the call or the time in advance record in local time. I put in the name associated with the device. As again, I stated earlier, I'm still talking about the device, but I sometimes have cases where I'm going to have 5 or 6 different people, so it just helps to make it clearer. And then for in case of a call or text, I show if it's an incoming or outgoing, what type, if it's a voice or a text or a voicemail. And then 8 is where that 105 is. That's the orientation of that cell tower. So that's the direction the center of that cell tower is pointed. And then if it's a time in advance record, then I have the distance 0.44, 0.29, 0.24, 0.24 miles. And that shows the distance of those arcs.
So page 7. Actually, let me go back, I'm sorry, page 5. We'll see here in a second, we just kind of saw that there are these colors and letters identifying locations. Are these the locations that you were asked to include in your mapping of the defendant's cell phone?
Yes, sir, I was provided these locations as being important to the case.
And you're told Billy Tremier's residence is at 4500 Pear Ridge,
Yes, sir.
and the Walmart 1575 7 North Point Road would be reflected as WM.
Yes, sir.
Diamond and Gold Exchange 7995 LBJ Freeway would be DGE.
Yes, sir.
The Enterprise Rent-A-Car 9850 North Central Expressway would be an E.
Yes, sir.
Mary Brooks 777 Custer Road is MB.
Yes, sir.
Preston Place 5000 Old Shepherd Place would be PP.
Yes, sir.
And Lou Harris 6609 Warm Breeze Lane is reflected as LH.
Yes, sir.
And this would be in every map that we're going to see here in your report.
Yes, sir. I mean, I zoom in and out, so sometimes not every location will be shown on every map. Basically, because I'll zoom in and out. There is a scale on every map, so sometimes I zoom in and zoom out, just depending on what's shown.
So, page 7. You're telling us that on January 30th, 2018, from 10:05 to 11:25, this is the approximate location of the cell phone device for the number 972-674-7527.
Yes, sir. What I have during this time is, I actually only had, during this time frame, I had one incoming call that went to voicemail at 10:16 a.m., and then everything else was time in advance. But when I talk about the built-in overlap of the network, the Walmart is kind of in the overlap of all these towers. And time in advance distance I'm given, for the majority of them, they're crisscrossing over in the Walmart. So this would be consistent with the device being in the area of the Walmart during this time. Now, could it be moving around this entire area, anywhere in those arcs during that time? Yes, I can only approximate the location, but it's consistent with it being in the area of the Walmart.
Okay, and I'm just going to go through each tower if that's okay.
Yes, sir.
And so we see here's Coit and Arapahoe and the Walmart that you were asked to identify. Is that right?
Yes, sir.
Okay, and we see a cell phone tower here. Is that right?
Yes, sir.
Okay, one down here off Beltline,
There's one in the south, yes, sir.
and then another one here,
Yes, sir.
and up here, Coit and Campbell almost.
Yes, sir, and I think I didn't state it earlier, all the green dots that you see on the maps, those are T-Mobile cell towers. So there are other towers that are shown where there's no usage, but I do show the network in the area because that helps me determine the coverage area of the cell tower.
Okay, so we've identified the cell phone tower. Now let's talk about sector. So let's just use this as an example. The sector of this cell phone tower, can you explain that?
Yes, sir. This tower, there are two sets of antennas pointed in the same direction. That's why I have two different cell IDs. But both of those cell IDs are oriented at 240 degrees, so they cover basically from 6 o'clock to 9 o'clock. Or no, 10 o'clock, sorry. Yeah, 6 o'clock to 10 o'clock on this. And then you see the arcs created by the time in advance. And there were a total of 57 time in advance records between 10:06 and 11:25, between .68 and .97 miles. And then there was one at 10:12 a.m. and one at 11:25 a.m. at 1.26 miles, which is that farther arc. And then the other tower.
And I might slow you down if that's okay.
Yes, sir.
Okay, so tower, sector, and now the time distance, we saw as an example, we call it that arc or hot dog thing.
Yes, sir.
As you said. So just to make sure we're following along, this is what you're referring to, right? These arcs?
Yes, sir.
Okay. And you're telling us that the cell phone tower, where we're pointed here over by J.J. Pierce High School, would the Walmart at Coit and Arapahoe be within the coverage area of that cell phone tower?
Yes, sir. And then it's also within the coverage area of those time in advance records for the majority of them.
Okay. So now, yes, sir, the timing advance records. You told us that there's 57, it says calls here, but you said transactions, or what word did you use?
Just time in advance events. The program will just list, if I go to this box, because obviously trying to show 57 individual events, the call-out box would cover the entire screen. So it just refers to any event as a call. So sometimes it might say there are 57 calls, and it might be 50 with nothing on it. That's the time in advance. 3 incoming calls and 2 texts. It might show that breakout in the bottom. In this case, there were 57 time in advance events between 10:06 and 11:25 a.m.
And the estimated distance from those time advance records, how you explained to the jury already, is 0.68 miles to 0.97 miles.
Yes, sir, except for the 2 that I specified that were at 1.26 miles.
And that would be what we see right here?
Yes, sir.
Okay. And the arcs represented from those time advance records, would that be consistent with the phone being in the area of that Walmart?
Yes, sir.
The cell phone tower that we see here, you have 4 time advance records
Yes, sir.
or events, and the coverage area for those. What is that?
See, sir, they're .82, .82, .78, .78, and that's represented by the arcs coming here that, when looking at the other ones, kind of crossed over the Walmart. But again, during those times, that device could have been anywhere in the coverage area of that tower at the arcs or short.
So, cell phone tower, sector, arc, based on the time distance. But you're saying that the cell phone device could be anywhere within this arc.
Yes, sir.
And kind of that same thing here from 1016, 1018, 1035, and 1038.
Yes,
Cell
sir.
phone tower here off Beltline, and the time distance is 0.87, 0.92, and 0.92 miles away.
Yes, sir.
And with that coverage area, which we see here, is that right?
Yes, sir.
Would that be consistent with a phone in the area of the Walmart?
Yes, sir.
And this last event at 10:05, this tower here, it says it's 1.16 miles away.
Yes, sir.
And so is it this arc that we see here?
Yes, sir.
So if you can see, would you agree that there's an overlap of these 4 cell phone tower arcs from the time distance records in this representation?
Yes, sir.
Okay. The location of Those overlaps is where?
The overlap is in the area of the Walmart. If I was like looking for a fugitive and I have these records, I would start, I'd have boxes of where to start looking. The first box would be, around the Walmart, and then I would start expanding it out to the coverage area of all these sectors and the overlap areas, but with the time advance, I'm able to narrow it down a little bit.
So but now I'm looking at page 8, and just for a reference, we just saw records from 10:05 to 11:25. Is that right?
Yes, sir.
Okay. So now we're looking at records from 11:26 to 11:38.
And basically, the phone starts to travel south, gets in the area of the Diamond and Gold Exchange, somewhere 635 and 75, and then 1132, and then starts traveling back north, and 1138 gets back up into the tower that has a coverage that includes the Walmart, with the time in advance distance being a little farther than the Walmart.
Would you agree with me that this is reflective of movement of a cell phone device?
Yes, sir. Basically, the device leaves the area around the Walmart, travels south, and then goes back up in that 12-minute time frame.
And just to compare the difference between page 8, where we just talked about how this is reflective of movement, compared to page 7. This type of this type of analysis, would this be consistent with someone, I guess, maintaining at a certain location?
It could be, but they still could be moving within that area. Just the next slide shows obviously a much grosser, larger movement.
Okay. And I'm just going to take that path of the cell phone device, if you don't mind.
Yes,
I'm going to
sir.
start up here where we're at 11:26:53. An
Yes, sir.
incoming call at the tower off Beltline.
Yes, sir.
Okay. And so you see 11:26, 11:27, but then it's 11:34, 11:35, and 11:35, all off the same tower.
Yes, sir.
Okay. But I'm going to focus on the 11:26 and 11:27 because we next have an event at 11:28 that, as you said, moves south towards Spring Valley.
Yes, sir.
Okay. And then moving further south, we have another event at 11:31 and 11:32.
Yes, sir.
Is that consistent with movement by the cell phone device?
Yes, sir. Travels south towards the 635-75 intersection.
And so if we kind of move over here towards this area where we have a cell phone tower off that line, and the times for that are 11:36, 11:37, and 11:37.
Yes, sir.
Okay. Does that coincide with, moving back to the left, the 11:34, 11:35, 11:35? Are those cell phone towers fairly close?
Yes, sir. And that basically shows that the phone's moving back up north at that time.
And back up north, ultimately, we see at 11:38, the cell phone tower at Coit and Campbell.
Yes, sir.
And you actually give an estimated distance at 0.82 miles,
Yes, sir.
and that's represented by this arc right here.
Yes, sir.
So, $11:38, and now we see here on that same day, 11:40 to 11:55 on page 9. Is that right?
Yes, sir.
All right. And I want to focus on these two boxes first. We see that same tower as the previous page at 11:38. Is that right?
Yes.
I call it Coit and Campbell.
Yes, sir.
All right. The sector and the coverage area by itself, would those include the Walmart?
Yes, sir.
Okay. And then furthermore, the time distance records tell you that from 11:40, 11:40, 11:44, and 11:48, the phone is between 0.73 miles and 0.82 miles away from that cell phone tower.
Yes, sir.
And your arc that we see here, would that include the Walmart?
Yes, sir, it would.
Now, at 1141, the cell phone was utilizing this tower a little bit south on Beltline. The coverage area for that is 0.92 miles. And so if here's the tower, here's the sector, and this arc,
Wrong arc, sir. It's a orange board, so it's going to be that arc. Yes, sir.
thank you. They're all pretty close, aren't they?
Yes, sir.
Okay. Would that be consistent with a phone in the approximate location of Walmart?
Yes, sir, it would.
And anywhere within that arc?
Yes, sir.
Okay. And so at 1150, the cell phone is using this cell phone tower, and the time distance is 0.82 miles.
Yes, sir.
So just as we've done, the arc again includes Walmart.
Yes, sir.
And if I go back to a couple pages I asked you as far as this overlap between multiple cell phone towers and the time distance records in this arc.
Yes,
right?
sir.
Would you agree that this overlap exists, again, right on top of Walmart?
Yes, sir.
And these events where we just described are from 1140 to 1148.
1150, sir.
I apologize, thank you. The next event is this cell phone tower off Arapahoe, right?
Yes, sir.
Okay. The sector of this, and this is at 1155, so 5 minutes after the cell phone tower and sector and timing distance consistent with being at Walmart. Now we're in a tower in a sector facing east.
Yes, sir.
I guess interpret that for me.
Well, the phone is moved, and it's moved towards the east, towards the Mary Brooks residence, utilizing that tower. That tower has coverage of Mary Brooks residence, but based on the time in advance, it is fairly close, within 0.1 miles of that cell tower. So it's traveling, possibly on Arapahoe Road, but I can't narrow that down, but the phone is moving at that time.
And the records don't reflect this, but what if the sector was facing back west? So instead of facing east towards Mary Brooks, the sector was facing back west towards Walmart. Would that change your interpretation?
Yes, sir. I mean, it still could be the phone was moving on Arapahoe Road, but it could be just farther west. So the sector is very important in the analysis because that lets me narrow down where the device could be.
And would you agree that this is consistent with moving towards Mary Brooks' home?
Yes, sir.
So we last left off here at page 9 at 1155, this cell phone tower right here off of Arapahoe. And I want to use that as a reference because on page 10, from 1155 to 1245, would you agree that this right here is that same cell phone tower on the previous page?
Yes, sir.
Okay. And you told us it was 0.19 miles as far as the estimated time distance, right?
Yes, sir.
And so 4 minutes later, so at 1155 we're here. 4 minutes later, we have 21 events, transactions, between 1159 and 1245. Is that what we're showing here?
Yes, sir.
And that's reflected by this cell phone tower right here, and with this sector facing Mary Brooks' home.
Yes, sir. And so if I just have the tower, I can say that tower has a coverage area that includes Mary Brooks residence, and then with the time in advance distance, it narrows it down to being more consistent with it being at Mary Brooks residence. But again, I can't state it was there. It was somewhere within the coverage area of those hot object arcs.
Would you agree that this cell phone device is moving closer towards Mary Brooks' home based on the movement from this cell phone tower here to the cell phone tower here?
Yes, sir.
And the timing advance records give us a range distance 0.34 miles to 0.44 miles for a period of 45 minutes. Is that what we're showing here?
Yes, sir.
So for 45 minutes, from 11:59 to 12:45, you're telling the jury that the approximate location of Billy Chimier's cell phone device would include Mary Brooks' home.
Yes, sir.
And that's from 11:59 to 12:45. Now I want to go back to just 30 minutes before that, 11:25. Actually, I'm sorry.
It'd be from 11:40.
Thank you. You know what I was going. Okay. So at 11:48, the cell phone is an approximate location including Walmart.
Yes, sir.
And then sorry, I'm making a mess up here. 1 second. So within 10 minutes, at 11:59, we're now in an approximate location in a coverage area of Mary Brooks' home.
Yes, sir.
And these records show utilizing this cell phone tower until 12:45. Is that right?
Yes, sir.
So 9 minutes later, we're looking at here, page 11, a representation of the cell phone device utilizing a tower near Diamond and Gold Exchange.
Yes, sir.
So 9 minutes after utilizing that tower at Mary Brooks' home, the defendant's cell phone travels to an area, you're actually telling us 0.34 miles to 0.53 miles from the Diamond and Gold Exchange?
Yes, sir. And from the base of the cell tower and that coverage area and time advance distance includes the Diamond and Gold Exchange. Again, I can only say it was in the coverage area of those. I can't say it was specifically at a particular location.
And so 124 events from 12:54 to 2:22.
Yes, sir.
And page 12 from 3:43 to 3:46. This little symbol here, what does that reflect?
That was the address for the defendant that I was providing.
And just so the jury can go back and recall, we're talking about 4500 Pear Ridge, is that right?
Yes, sir. And on each map, there's a little key that kind of, just gives the name of each location.
Thank you. You were also asked to review phone records from January 31st, 2018. So one day after what we just saw, is the cell phone utilizing a tower and sector within the range of the Diamond and Gold Exchange?
Yes, sir. I was asked to look on 31st if the device ever was in the area of the Diamond and Gold Exchange. And between 10:54 and 12:20, the time advance data was consistent with that device possibly being in the area of the Diamond and Gold Exchange, using a tower with arcs coverage area that includes the Diamond and Gold Exchange.
And so this is January 31st. Back out, sorry. Would this be incredibly similar to the mapping and representation of the defendant's cell phone device on January 30th?
Yes, sir.
In fact, it's the same tower, same sector.
Same tower, same sector, and the time advance difference is actually the same, 0.34 miles to 0.53 miles for both.
Now, March 15th, page 15 of your report is a representation of the defendant's cell phone from 8:27 to 1:57. And I just want to look at it from a general view here first. Down here to the bottom left, you already told us, but once again, what does that represent?
That's the address associated with the defendant.
And is there a cell phone tower right here?
Yes, sir.
So that green dot are other cell phone towers.
Yes, sir.
And not just other cell phone towers, but these are specific to T-Mobile, right?
Yes, sir. I'm only showing the T-Mobile network.
And while we're talking about this, well, I'm sorry, I'm speaking about a different one. So I'm just going to move up here to cell phone tower. And the time on this tower is 8:50 and 8:51.
Yes, sir.
Okay. But that's not, I guess, the first representation of the call records for this date. So I'm going to go ahead and move over to that, which is 8:27 through 1:57. We're at a cell phone tower, Plano Parkway, and I can't see. Do you know what street that is?
It's 289.
Okay. So you tell us that there are 367 events, including phone calls, at this cell phone tower in this sector.
Yes, sir.
Okay. Now, we see lots of green here, and we see a range of 0.29 miles to 0.68 miles.
Yes, sir.
Right? In this graph, this representation of the defendant's cell phone, does it include the coverage area of Preston Place?
Yes, sir, it does.
Preston Place being 5,000 Old Shepherd.
Yes, sir.
So, just take a step back. So, the tower and sector themselves, those records would be within the range, and then the timing advance tells you the exact approximate location of this arc. Is that right?
The time advance will narrow it down, but it's consistent with the cell tower above being in the area of the Preston Place.
Okay. And that's because we see the cell phone tower further north, 29 events between 8:56 and 1:05.
Yes, sir.
So kind of an overlap in time from these records right here.
Yes, sir.
Okay. 29 events, and we have a 0.24 miles to 0.73 miles.
Yes, sir.
And just as we've done with the previous records, we see this overlap. Would you agree with me?
Yes, sir.
All right, so the overlap we see, I guess probably 0.73 miles, so less than a mile away, the overlap from the other tower is including Preston Place. Would you agree with that?
Yes, sir.
So would you agree that the cell phone is consistent with being within an arc that includes Preston Place at 5,000 Old Shepherd Place?
Yes, sir, for the majority of the time. Obviously, some of those are short, so there was some movement, but it was such a large amount of activity in the area. They would break it down, but it's consistent with the device being in the area of Preston Place during that approximately 4-hour time frame.
And I'll go back here, because I started here, 850, 851, and 108. We're at 1.89 miles away.
Yes, sir.
And this arc is that representation of that distance?
Yes, sir, it is.
Okay. And again, you see is that an approximate location of the overlap of the other two cell phone towers?
Yes, sir.
So from 8:30 to 1:57, how long is that?
8:30 to 1:57, so 8:30 to 2, rounding is 5.5 hours.
So so page 15, right, Preston Place, 5.5 hours, last being 1:57. Page 16
Yes, sir.
is a representation of the defendant's cell phone device at 2:54 to 3:37. And I guess I've kind of identified these before, but are these the same cell phone towers from some of the previous maps that we've already reviewed?
Yes, sir.
I guess let me review this one first with you. I'm sorry. So again, you see a cell phone tower I call it the Coyne Campbell Tower. We have 62 events between 2:55 and 3:37, is that right?
Yes, sir.
And the estimated distance is 0.73 miles to 1.26 miles from that cell phone tower.
Yes, sir.
And so, here are the arcs that represent that distance.
Yes, sir.
Okay. And so, further south, we see another cell phone tower. The tower, the sector, the range, would that be within the coverage of Walmart?
Yes, sir.
And the timestamps on these are at 2:56 and 3:35, and the time distance is 0.82 miles and 0.78 miles.
Yes, sir.
All right. And so, again, that time distance in that arc, consistent with the phone being a principal location of that Walmart.
Yes, sir. They have a coverage area that includes Walmart.
And then last we have a third cell phone tower right here off Beltline, and that time is 2:54, 3:28, 3:33, and 3:35. And the time distance estimation is 0.87, 0.92, 0.82, and 0.87 miles.
Yes, sir.
So, tower, sector, arc,
Yes, sir.
right? Those three towers and the arcs from those towers, is there, just as before, the overlap at that same Walmart?
Yes, sir.
And so that same Walmart, that same overlap that we just talked about on January 30th, is that right?
Yes, sir.
March 19th, I'm going to call this the morning, from 8:18 to 9:36, we're looking at a representation of the defendant's cell phone device, is that right?
Yes, sir.
And PP is Preston Place,
Yes, sir.
5,000 Old Shepherd,
Yes,
right?
sir.
And I'm going to go back to page 15. Would you agree that the cell phone towers are similar?
Yes, sir. In this case, it uses the eastern face of the tower to the north for actually 6 of those events. But it's consistent with the phone being in that area or a little to the east.
Okay. So on March 19th, the morning of March 19th, from 8:18 to 9:36, we have this cell phone tower, this sector, and this time distance estimate from 0.53 miles to 0.63 miles. Is that right?
Yes, sir.
And I feel like I'm saying this a lot, but would that arc include the Preston Place?
Yes, sir, it would.
And so you can tell us that the phone is approximate location of anywhere within that arc.
Yes, sir.
And from 8:21 to 8:45, we have 21 events, and those are from this cell phone tower right here.
Yes, sir.
Right. But this looks a little bit different, I guess, than some of the other cell phone towers that we've reviewed previously. Is that right?
Well, in this case, I had usage on 2 sectors of the same tower.
Okay. So, as I come on tracing here in a western direction, would that include Preston Place?
Yes, sir.
All right. And now we have, I'll call it east. You can probably tell me in degrees better than I can, but basically a sector facing a different direction.
Yes, sir. That's 120 degrees is what it's facing, but it's east-southeast.
What does that mean?
It's basically utilizing the other sector of that tower, so the device during those events would be somewhat to the east. It could be all the way up to the very top of that sector, in that, up close to the Haggard Library, but it's still somewhere in the coverage area of those arcs in the general area. But that tower, there is some back lob off of the tower, but Preston Place probably does not have coverage from the east facing of that tower.
And these little circles here, is that the time distance?
That's just
overlap of those two arcs?
That's the overlap, because the program draws, as you can see, the hot dogs or the arcs go outside these sector arms, because the tower is not 120 degrees, it's about 130 degree total coverage area, so it represents that little bit of overlap.
And so, from March 19th at 8:18 to 9:36, the defendant's cell phone is utilizing cell phone towers less than a mile away from Preston Place.
Yes, sir.
And just for comparison, the defendant's home, 4,500 Pearridge, is down here,
Yes, sir.
and within a mile away from a T-Mobile cell phone tower.
Sir?
Is that very close to a T-Mobile cell phone tower down here?
Yes, sir.
Just for comparison, we're talking, we left off at 9:36, and on page 19, we're now at 10:10 to 11:45.
Yes, sir.
And so we see a comparison where the phone was previously utilizing cell phone towers up here towards Plano Parkway, right? We talked about Preston Place. Now we see that there are 270 events from 10:10 to 11:45 at this cell phone tower. Would that be consistent with the phone being in approximate location of 4,500 Pear Ridge?
Yes, sir.
Let's step back. March 19th in the morning, we're less than a mile away from Preston Place
Yes, sir.
until 9:36, and at 10:10 to 11:45, we're within a mile of 4,500 Pear Ridge.
Yes, sir.
And on page 20, 11:57 to 2:19, we're now within a mile of a cell phone tower of the Diamond and Gold Exchange. Is that right?
Yes, sir.
This is the same tower that we've seen previously in regards to the Diamond and Gold Exchange.
Yes, sir, with one other tower to the east also having usage or a time in advance event during that time frame.
And so 437 events from 11:57 to 2:19. And this also includes some phone calls, is that right?
Yes, sir.
And so 0.24 miles to 0.63 miles. And so the arcs that reflect that time distance. And at 2:19, we have another event, 0.53 miles. So this tower, this sector, that distance. Is that
Yes,
right?
sir.
Okay.
Yes, sir.
And again, the overlap include an area of the Diamond and Gold Exchange.
Yes, sir.
So 2:19 on March 19th, and now March 19th at 3 o'clock to 3:22. We see that there are 53 events from 3 o'clock to 3:22, and we're 0.10 to 0.29 miles is the time estimate. Is that right?
Yes, sir.
Now, again, kind of like the previous slide in regards to Preston Place, we see another sector being utilized.
Yes, sir.
Interpret that and explain that to me, please.
Well, in this case, that phone is very, very close to the base of that tower, so it probably can see both of those sides pretty easily. So the bouncing back and forth between those makes sense. It's kind of in that overlap of the two sectors, being that close, and being right on the line between the two sectors.
So, just go back from 8:18 to 9:36, less than a mile from Preston Place. 10:10 to 11:45, less than a mile from 4,500 Pear Ridge.
Yes, sir.
11 minutes later, 11:57 to 2:19, less than a mile from the Diamond and Gold Exchange.
Yes, sir.
And then from 3 to 3:20, less than a mile from the Enterprise Rental Car.
Yes, sir.
I don't think I actually ever asked you what that E represented, but
I don't remember if you did, but it's an Enterprise rental car.
okay. Alright, agent said, look, I'm showing you page 23, and this is from March 20th, 9:52 to 2:55.
Yes, sir.
For call detail records, we've already told the jury that these are for incoming or outcoming calls, is that right?
Calls and texts, yes, sir.
And so if someone doesn't make a phone call, doesn't receive a phone call, and doesn't send a text message or receive a text message, would there be any records, any call detail records?
No, sir.
So, as opposed to the timing advance records, which include just background cell phone activity, you're dependent here on call detail records for when the phone is actually in use by the person.
Yes, sir. The device is, in a call or text.
Sorry. And so, is that the type of records we only have for March 20th?
Yes, sir. I did not receive any time advance records from March 20th.
Okay. And so, we would have the tower sector, but as the jury's already seen, that time distance, that arc, that would not be represented anywhere on March 20th.
No, sir. With CDRs, I can just say the coverage area of the tower can be anywhere within the coverage area of that tower. I can't narrow it down to those arcs.
Okay. So March 20th from 9:52 to 2:55, and we have the Walmart off Arapahoe and Coit, and we have a cell phone tower. I called it J.J. Pierce, or I called it Coit and Campbell. We have another cell phone tower here, up here, and down south, actually facing a different direction. Would you agree with me?
Yes, sir.
Okay. So the time range on these is pretty vast because there were only, I guess, 5 phone calls. There were no text messages, but 5 events for you to map. Is that right?
Yes, sir.
And so what you do is you're able to, I'm just going to go with each one. At 12:01, you had Billy Tremere's device had an incoming call, and it's utilizing this cell phone tower here.
Yes, sir.
Okay. What kind of range are we talking about with this tower sector combination?
This tower would have a coverage area where it would be the dominant tower a little past Hillcrest Road. So it would not have a coverage area that includes the Walmart.
And you said Hillcrest Road, I'm going to point it out here.
Yes, sir.
Okay.
Possibly maybe a little past Hillcrest Road, but it would not have, be the dominant tower that the phone would choose for if it was in the area of the Walmart.
And at 1:53, we had an incoming call utilizing the cell phone at Hillcrest and Arapahoe.
Yes, sir.
Okay. And this tower sector combination, what can you tell us about that?
That one would have coverage. You see that there is a tower right at the intersection of Coit and Arapahoe. There's a green dot right there at the intersection of Coit and Arapahoe. That cell tower is what we refer to as a picocell. It is a small cell phone. There's a T-Mobile store right there. So they have a small cell tower that covers the T-Mobile store. So when you go to buy your phone at T-Mobile, you're very impressed with the coverage because there's a small picocell inside the store. So that would have very limited influence outside of that store. Those picocells have very, very small coverage areas. So I show it, it is a tower, but I did check it, and that is a small picocell. So the tower at 152, its range, the dominant tower would be the tower by J.J. Pierce High School, but that 152 would have some coverage area of the Walmart, but the dominant tower for the Walmart would be the one by J.J. Pierce.
And Coit Campbell, I called it J.J. Pierce. So this phone was utilized by Billy Tremere's cell phone at 9:52 at an incoming call, and 11:42 there was an incoming call at this cell phone tower with this sector. The range of that tower, would that include the Walmart at Coit and Arapahoe?
Yes, sir, that tower has a coverage area that includes the Walmart.
And we've seen that tower being utilized often by this defendant's cell phone on January 30th and March 15th, is that right?
Yes, sir.
And from that same cell phone tower, the jury's already seen the arc from the time distance records from that same cell phone tower that cover that Walmart, is that right?
Yes, sir.
And last we have a incoming call at 2:55 down here at Beltline and Coit. What can you tell us about that tower sector combination in the direction?
That has a coverage area to the south-southwest. It has no coverage of the Walmart, Hillcrest, and of course I'm covering the road. That road right there, Birch Fields, and probably end before it gets to that Birch Fields Park area, but it has a coverage area down to the southwest of that tower.
Okay. And just taking a step back now, and seeing that this is a cell phone device from 952 to 255, and this is the area, or these are the towers and the sectors being utilized by that cell phone device. What can you tell the jury in regards to this type of activity?
At 9:52 and 11:42 a.m. is consistent with, that phone is using a tower that covers the Walmart. At 12:01, it is moved west of the Walmart. At 1:53, it is utilizing a tower in a sector that has a coverage area that is to the east of the Lou Harris address. And then at 2:55, is utilizing a tower to the southwest of the Walmart. Coverage area doesn't cover any of the pertinent addresses.
And this, would you agree that this be consistent with moving in this general vicinity?
Yes, sir. The phone, obviously, there's large gaps in time. So like between 1:53 and 2:55 in an hour, I can't say where that device went during that hour. It came back to the same area, but it could have driven 30 minutes and turned around and driven back. I just don't have any records to say where it was during that hour.
You map with what records you have.
Yes, sir.
If you don't have any records for a certain time, you can't tell an approximate location of that cell phone device.
No, sir.
On March 20th now, we're talking about 4:56 to 4:59. And so just to reference, the last cell phone activity in regards to an incoming or outcoming call or text message was at 2:55.
Yes, sir.
All right, so from 2:55 to 4:56, I'm going to say a 2-hour gap. Would you agree with me?
Yes, sir.
Okay. So no incoming or outcoming calls or text messages for 2 hours. And the next activity is a outgoing phone call at 4:56
Yes, sir.
at Arapahoe and Hillcrest.
Yes, sir.
And LH, is that the residence of Lou Harris?
Yes, sir.
And were you given, that address would be 6609 Warm Breeze?
Yes, sir.
Yeah. And the next cell phone activity is an outgoing phone call at 4:59.
Yes, sir.
And that cell phone and tower being utilized, I'll call it Preston and Beltline, is that fair?
Yes, sir.
And if I zoom out, is this tollway?
Yes, sir.
Okay, and to travel towards 4500 Pear Ridge or Village Humor's residence, would you utilize either an access road or something over here on tollway and go north? Is that fair to say?
That'd be a logical route.
Okay. Now, this outgoing call at 4:59 with this tower in this sector, what can you tell us about whether or not that would include Lou Harris's residence?
The dominant tower for Lou Harris would most likely be the tower sector to the west of the tower to the north, but the tower, the Beltline and Preston would have some coverage, but I don't believe it would be the dominant tower.
Can I give you a scenario and ask if these records would be consistent with that scenario?
Yes, sir.
We have Lou Harris's home at 6609 Warm Breeze. If the cell phone device left that home, traveled towards Hillcrest, made a phone call at 4:56, traveled south on Hillcrest towards Beltline, made another phone call at 4:59, would that be consistent with the tower sector combinations that we see here?
Yes, sir. That's one path that phone could have taken.
And you can't say whether this device took that path, but if that were a path, hypothetically, these records would be consistent with that.
Yes, sir. But obviously I can't state that's what occurred.
Correct. So an outgoing phone call at 4:59, right? We're at Preston and Beltline, and for reference, this is toll road. And I'm showing now March 20th from 4:56 to 5:55. So this representation would include the two phone calls at 4:56 and 4:59 that we just talked about. Is that right?
Yes, sir.
Okay. And for reference, we have Lou Harris's home here.
Yes, sir.
Okay. And this tower sector at 456, Arapahoe, and I'll call, Hillcrest, is that fair?
Yes, sir.
Okay. And then the 459 outgoing call at Preston and Beltline.
Yes, sir.
All right. And all this was approximately 2 hours from the previous cell phone use in the form of an outgoing or incoming call.
Yes, sir. There's approximately 2 hour gap.
So nothing in those 2 hours.
No, sir.
All right. And so we see phone call at 456, phone call at 459, and then the next activity is up here. Would you agree in the area of 4500 Pear Ridge?
Yes, sir. 516, and then 517 it uses the tower to the south, and at 516 it uses the 120, so the southeast side of that tower. So probably with that time it was somewhere in between those two towers, kind of in the overlap. And then at 555 is a tower that has a coverage area that includes the residents, but again, it basically shows the phone from 459 to about 516 getting back into the area of his residence.
So, we kind of already said it, but I'm going to go back from 456 to 555. The path of travel would be consistent with going from Arapahoe to Hillcrest to Beltline and traveling north where we know the defendant lives at 4500 Pear Ridge.
Yes, sir, that is one path that phone could have taken.
And at 459, we're down here at Preston and Beltline, and the next phone call that we're able to map is at 516 in a tower that's being utilized within, I guess it covers the area of the defendant's home. Fair to
Yes, sir.
say? So 17 minutes later, from 459 to 516.
Yes, sir, the phone gets in the area of the defendant's residence.
And we pass the witness.
All right, well, ladies and gentlemen, this is an awesome time to take our morning break. We have been going consistently since, 9 o'clock or so. So we will go ahead and take our morning break. I will give you, your time, 15 to 20-minute break. You know the rules. Push the red button, we'll come running, and we'll start when you're available. Thank you so much.
All right.
well, we are returning from our break, and where we left off was Mr. Enigmastis had just finished the cross-examination of Agent Sedgwick, and he has now passed the witness over to the defense. Mr. Watson, are you ready to proceed?
Yes, ma'am.
You may.
Agent Sedgwick, I'm Mark Watson, and we talked this morning, correct?
Yes, sir.
And you've been with the FBI for how long, since 1998?
23 years, yes, sir.
23 years. And during that period, is it fair to say you've done a lot of things inside the FBI?
Yes, sir. Besides an investigator, I've been a SWAT team member, breacher for 20 years.
And are you pretty familiar with the investigative techniques that the FBI has used or used in law enforcement and or prosecution in your time there?
I mean, I'm familiar with most of it. I wouldn't say I'm intimately familiar, but I know what we do to investigate cases, yes, sir.
In the first 10 years you were there, you were in school a whole lot, I guess, right? Or when I say training?
Off and on, yes, sir.
Okay. And you've taken classes on how to testify in front of a jury, correct?
Yes, sir.
And how many times do you think you've testified before? Yes.
Over 80 times, sir.
Okay. Your conclusions, can they be affected by buildings, topography, obstructions, or whether or not a phone call was made inside or outside of the building?
Yes, sir. All that can affect the coverage area of the tower, but that's what the engineers do. They design the network, and that's part of my training to understand how that not interferes, but how that affects the coverage area of the cell tower.
Okay. And did you run this data through a program?
Yes, sir, through mapping software.
And what's the name of the software?
This Gladiator Forensics is the company.
So you take the raw data and you enter it into, what's the name of the software?
ESPA.
Vespa?
ESPA. ESPA.
So you plug it in there and then it comes out with the, do you do the maps or does the program do the maps?
I do the maps, sir. It plots everything for me and hand draws the sectors, but I will also take my data, run it through a different mapping software to make sure there's not a mapping software issue. We have a peer review where another cast agent will review my work to make sure there's not a mapping issue. They'll use a separate mapping software, and when I first started, I did it by hand.
One bit of software did the data crunching, and then you using different software did the mapping, I guess, close to that? Is that close to accurate?
No, sir. I use one mapping software that plots everything. Then I use when a peer review is conducted, another cast agent will take that data, use a different mapping software to check my work to make sure there were no errors, there's no mapping errors. And in this case, I also did that review myself.
And what was that agent's name that reviewed your work?
I don't remember. I'm blanking on who did this one because I sent several things out for peer review recently. And I don't remember, sir.
All right. Would you agree that some scientific theories formerly used by law enforcement at one time are no longer used?
Yes, sir. There's been stuff that, yes, sir.
For instance, hair follicle, is that an example?
Yes, sir, that's one.
And the FBI that was pretty extensively used, correct?
In my career, I've never used hair follicle.
But do you know whether or not it was used quite a bit?
I don't know how much was used. I know it was used, sir. I don't know to the extent it was used.
Okay, do you know if it was ever used by the FBI?
Yes, sir, I know it was.
Okay. What about bite mark evidence?
I don't know if the Bureau used bite mark evidence. That's another thing I've never used.
Okay. Are you aware whether or not that bite mark evidence used to be used quite a bit?
I know it was used, yes, sir.
And it's no longer used, correct?
I believe it's not
I
used.
mean, to the best, I'm not asking you a perfect question, but you, to your knowledge, is no longer used, correct?
That is my understanding, sir, but I do not know.
Pass the witness.
Mr. Anastas?
Yes, Judge, thank you. Judge, may I ask the witness to step down?
Yes, you may step down.
Agent Sedgwick, we see published here your exhibit, page number 7 from exhibit 3.
Yes, sir.
And I want to ask you, based on the defendant's cell phone and your approximate location from 10:05 to 11:25, would that be consistent with the defendant's being at Walmart?
Yes, sir. The coverage area includes the Walmart.
So on January 30th, if the jury's heard that a Nissan Altima is on video from 11:38 to 11:51, the cell phone device, Billy Chimere, will be consistent with that.
Yes, sir. That would be that the video is corroborated, or the video corroborates the cell site location being in the same area.
The jury's heard evidence that Mary Brooks, who was last seen alive at Walmart on January 30th at 11:51, was found dead with her groceries still out and a ring missing that was later linked to Billy Chemere's OfferUp account. What can you tell us about the defendant's cell phone records in regards to 10 minutes after leaving that Walmart?
It's the cell data is consistent with the cell phone being in the area of the victim's residence.
And then 9 minutes later, if the defendant has a cell receipt to Billy Chemere on January 30th, what can you tell us about the defendant's cell phone in regards to the time from 12:54 to 2:22 in relation to the Diamond and Gold Exchange?
It's consistent with the device being in the area of the Diamond and Gold Exchange.
If a sales receipt has been admitted into evidence for Billy Chemere at the Diamond and Gold Exchange in regards to the phone call records on January 31st, would those be consistent with the defendant being at the approximate location of the Diamond and Gold Exchange?
Yes, sir, it would.
On March 15th, if a witness testified in front of the jury that they observed a silver Nissan Altima from 8 to 10:30, or I'm sorry, from 10 to 12:30 at 5,000 Old Shepherd Place. Would Billy Chmiermier's cell phone be consistent with that?
Yes, sir, it would.
In fact, the time frame of that would be what?
That I have it was 8:27 a.m. to 1:57 p.m.
And if there is video, and the jury's seen video of Billy Chmiermier at Walmart at Rapid Hill and Coy from 256 to 308,
Yes, sir. The cell data would be consistent with him being in that area.
on March 19th, the jury heard evidence that Mary Brooks was smothered and emergency services responded at 9:40. Her ring was taken. What can you tell us about the location of the defendant's cell phone prior to 9:40?
Between 8:18 and 9:36, the cell carrier data, the CDRs, and time advance was consistent with it being in the area of 5,000 Old Shepherd Place.
If the jury's heard evidence that this photograph was taken at 10:29 on Billy Chmiermier's cell phone device, posted on offer at 10:31, what can you tell us about the location of the defendant's cell phone at that time?
It's consistent with being in the area of his residence.
And the jury's seen video, and they've heard from witnesses that Billy Chmiermier was at the Diamond Gold Exchange at 1 o'clock, was at Starbucks at 12 o'clock, selling a ring identified as the ring taken from Mary Brooks no later than 9:40 a.m. that morning. What can you tell us about the defendant's cell phone records in regards to being at the Diamond and Gold Exchange?
It's consistent with him being at the Diamond and Gold Exchange during that time, the device.
The jury's seen video, and they heard from a witness who stated that Billy Chmiermier was at Enterprise Rental Car at 3 p.m. on March 19th. Would the phone records that you apply to be consistent with that?
Yes, sir.
And on March 20th, 2018, you explained to the jury the reason why there would be a lack of cell phone records for that day. Is that right?
I just did not receive any time advance for that time frame.
The jury's seen video of Billy Chmiermier leaving Walmart on video at 3:28, and Lou Harris leaving Walmart at 3:29. At 4:56 and 4:59, Billy Chmiermier's cell phone device makes 2 phone calls. Would those phone calls be consistent with the path of leaving Arapahoe, driving down Hillcrest, and taking Beltline towards Tollway to go up north?
Yes, sir, it would.
And the jury has seen and heard evidence that Billy Chmiermier was in possession of Lou Harris's keys. And Lou Harris's groceries after leaving Walmart were found left out.
Your Honor, I object that the prosecution is testifying.
I'm gonna overrule that.
And Agent Sedgwick, evidence has been in front of the jury that Billy Chmiermier was in possession of a red jewelry box and other belongings belonging to Lou Harris that we just spoke about at 6609 Warm Breeze. What can you tell us about the location of the defendant's cell phone device at this time?
That between 4:56 and 5:55 PM, the phone returned to the area around his residence.
And so looking at these dates, January 30th, March 15th, March 19th, and March 20th. In regards to Mary Brooks, Mary Bartel, and Lou Harris, are these cell phone records that we see here consistent?
Yes, sir, they're consistent with the other evidence and the device being in the area where those crimes took place.
Are they reliable?
Yes, sir.
Okay. And do they support the evidence of Billy Chimier's whereabouts that was admitted on January 30th, March 15th, March 19th, and March 20th?
Yes, sir. It corroborates that evidence that that device was in those same areas.
And specifically on the date of January 30th, March 19th, March 20th, all days where women were smothered with pillows and the jewelry was stolen.
That's my understanding, yes, sir.
Lastly, and Judge, can we take these down and let Agent Seba get back to his seat? Judge, I'll finish up, I'm sorry. Okay.
That's okay.
Agent Seba, you were asked to review these records to see whether Billy Chimier's cell phone device was ever in Fort Worth.
Yes, sir. I was asked between March 15th and March 20th to see if the device, if I had any records that placed the device in Fort Worth.
And so, was the defendant's cell phone device ever in Fort Worth during those times?
No, sir.
Judge, we'll pass the witness.
All right, I'll let the witness step back and, unless Mr. Watson, did you want to use the boards or?
No, Your Honor, we don't have any more of Agent Sedgwick.
Okay. All right, thank you. So maybe this witness be released?
Yes, Judge.
All right, Mr. Doctor?
No objection.
All right, you are free to go. Thank you so much.
Thank you, Your Honor.
All right, State, you may call your next witness.
Call Dr. Bernard.
Hello, doctor, how are you?
Good, yourself?
I'm good. Do you so solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, then you are welcome to testify with or without your mask.
No joke with that.
Okay. Mr. Fitzmartin, you may begin.
Thank you, Judge. Can you please state your name
Jeffrey Barnard, B-A-R-N-A-R-D.
and how are you employed?
I'm the director of the Southwestern Institute of Forensic Sciences and the chief medical examiner for Dallas County
How long have you held that position?
since 1991.
And so I'm assuming then that you are a doctor.
I am a medical doctor.
All right, tell me about your training and experience to be a medical doctor.
I attended Texas A&M University and received a Bachelor of Science in Medicine degree. I attended Texas A&M College of Medicine and received my MD degree. I served a one-year general surgery internship at Scott and White Hospital in Temple, Texas. I served a 4-year combined anatomic and clinical pathology residency at Scott and White Hospital, also in Temple, Texas. I served a 1-year fellowship in forensic pathology at the medical examiner's office in Suffolk County in Long Island, New York. I'm board certified in anatomic pathology, clinical pathology, and forensic pathology. I'm a diplomat to the National Board of Medical Examiners. I'm licensed to practice medicine in the state of Texas. I've been licensed in New York. I worked as an emergency room physician on a part-time basis during my residency and fellowship. I'm also professor of pathology at University of Texas Southwestern Medical Center, and I'm the current chairman of the Texas Forensic Science Commission.
Now, Southwest Institute of Forensic Science and the medical examiner's office there that you run, is it a teaching environment there at that establishment?
It is.
And tell us about that and your role in that.
Yeah, so as part of the Institute, which is both the medical examiner's office and the criminal investigation laboratory. We also have a fellowship in forensic pathology. Similar to what I did in New York, we have a similar program at the medical examiner's office here, whereby an individual who has the appropriate qualifications spends a year training and doing autopsies under the supervision of all the medical examiners.
And we heard earlier from Dr. Travis Danielson. Was he filling one of those roles with his time here at the Medical Examiner's Office?
Yes.
And he testified about an autopsy that he performed on a Lou T. Harris in this case. Did you supervise him in that autopsy?
Yes, I was the supervising pathologist on that particular individual case.
Now, you might not have supervised him on all of his. You have other medical examiners there at your office. So.
Right, we break it up to, there's an individual each week who's in charge of supervising the fellows during that week, and that was my week.
Okay. And so you were there and participated in the autopsy of Lou T. Harris.
Correct.
Now, I want to direct your attention first to some of the findings that were found in Ms. Harris's case. We saw in State's Exhibit number 223 that the last page of that, the first signature on there is Travis Danielson, is that right?
Yes, sir.
And the second signature is yours.
Right, and that by definition is the person who's the supervising medical examiner.
And then you go down, and the rest of the medical examiners that were on staff at that time, do they review the findings? There we go. Did they review the findings that are found by you and Dr. Danielson and sign off on the autopsies as well?
Right, they reviewed the report, then they reviewed all the photographs. Some of them may have seen that live at the time of the autopsy, and then they agreed with the cause and manner of death and signed the report.
Okay. And so we had heard last couple of days, State's Exhibit number 208, and Ms. Harris's face, and showing these the petechia that exist in her face. Is that what we're seeing in 208?
Yes, on both the right and left side.
And Dr. Bernard, have you ever had the occasion to do an autopsy on an individual prior to Ms. Harris that had been smothered?
Yes, both children and adults.
Okay, and how do you know in those cases that the individual had been smothered?
Well, in the case of the children, one of them, there was a confession, and the airway was obstructed by a plastic bag. The other was my decision based on finding the infant face down in a pillow with bruising on the back of the head, really consistent with fingerprint type impressions, though I couldn't say that for sure, but that was my conclusion, my determination. The other elderly individual who was a smothering, that case had florid petechiae on the face and neck, and that person was smothered by her spouse, who then wrote a note listing that he had smothered her with a pillow, and then he overdosed himself. So we knew de facto, based on his own statements, what he had done.
So through your training and your experience then, when you saw the state that Ms. Harris was found in, were you able to confidently call this a smother?
Yes, but you take into account the entire picture. With the investigative information we had at the time, the findings that were there, that was totally consistent with the smothering.
And I kind of jumped ahead. I guess what my point is, the state of the body in and of itself, the indications that you saw there would be consistent with the other things you found in a smothering case.
Yes.
Maybe not enough for you to call it a smothering case without other information.
Yeah, well, you know, the petechiae are florid, and a little more so than some of the other things that can cause it. But in general, in isolation, you wouldn't call it straight on that.
Sure. So, State's Exhibit number 211, looking at Ms. Harris's cheek. Also there, you were seeing on the left-hand side, you'd see that same petechia.
Yes, sir.
Now, she was found on her left side, kind of facing down. And is there a significance then to State's Exhibit number 214 in seeing that on her right side, we still see that petechia existed? Tell us.
Right, yeah, so if you're trying to compare what may be gravitational effect or positional effect, you know, the left side being down, those can be embellished maybe more just based on the fact there's some gravitational effect. But now you've got some on the right side too, and then again, you take in the whole picture, and it's totally consistent with the smothering.
And then, were you also made aware then that of the, you said that you used other information in that Mr. Tremere was, or there was an individual that was arrested with her possessions, and that she had been alive just 2 or 3 hours before that in the same location with that individual. Does that type of information go into your determination then of how to call the manner and means of the deceased?
Well, you have to put the whole picture together. So part of making a determination of the cause and manner of death is taking into account your findings, what scene findings may be present, what investigation findings may be present before you make a conclusion.
And you use that in this case?
Yes.
And was it the manner and means of homicide by smothering?
Yes.
So basically, as a medical examiner, you're not only a doctor, you're also somewhat of a detective or investigator.
Well, I don't know whether that's a compliment or an insult, but I guess maybe you could put that in, but yes, there are components of that into it.
I promise you, I term it as a compliment. I promise you that. Okay, so at some point in time, were you asked to look back at an unattended death of an individual by the name of Mary Brooks?
Yes.
And were you asked, Ms. Brooks you were not able to perform an autopsy on Ms. Brooks?
That's correct.
At the time that she was found, how did you all, or as far as that investigation, how was her death classified at that time?
Originally?
Yes.
It was determined at that time with the information available that it was a natural death.
Later were you provided through the Richardson Police Department more information as this investigation went on?
We were notified that there was further investigation going on, that there may be more involved than just what we originally thought had occurred.
Okay. The jury has seen photos from the scene of Mary Brooks' house. Were you shown those?
Yes.
The jury has seen body-worn camera from Officer Harris going over the investigation of Miss Brooks' body. Were you shown that, and did you go through that?
Yes.
The jury has heard about cell phone data that places Mr. Chemirmir's phone in the location of Mrs. Brooks' house at the day before she is found. Were you aware of that?
Yes.
The jury has heard that a Nissan Altima, which was driven by Mr. Chemirmir, was seen leaving and following the vehicle of Mrs. Brooks. Were you made aware of that?
Yes.
I'm going to object to answer these questions. He's asking what this jury was made aware of, and at the time of him making or reviewing these reports, he had no idea.
No, I'm asking him, I said the jury has heard of this. Were you made aware of those facts? I wasn't saying that he's made aware that the jury's heard of this. I'm saying there's cell phone data, there's videos, there's all this. Was he made aware of those in his investigation of Mrs. Brooks' case? That's my question.
Then I would ask him to phrase it properly, Judge.
Okay. So, objection overruled, and if you would just kind of rephrase it a little better.
Yes.
Thank you.
I think that's basically the last part of it. You know that there is video out there of a car that's associated and connected to Mr. Chemirmir following Ms. Brooks the day before she was found.
I was made aware of that, yes.
You were made aware that a unique ring belonging to Mrs. Brooks was being sold on a offer-up account that was possessed by and used by Mr. Chemirmir.
I was aware of that, yes.
Permission to approach?
You might.
Did you then, after hearing all of that information and looking at all the photos from the night, the body worn camera, the cell phone data, the videos from Walmart, all of that information, did you then choose to change the finding in this case?
I did, yes.
Okay. State's Exhibit 292, is this your full and abstention report?
It is.
293, is that a redacted portion?
I see, I just wanted to clear. Yes,
Okay. And then 321, is this the cause of death report, Jim?
yeah, this is the amended cause of death and manner of
Judge will offer State's Exhibit 292 for record purposes, and 293 and 321 for all purposes.
No objection, Judge.
All right, so State's Exhibit 292 will be offered for record only. State's Exhibits 293 and 321 will be admitted for all purposes.
Permission to publish?
You may.
Okay, State's Exhibit 293, you place on here just some biographical information of Mary Brooks, white female, 87 years old, date of birth, and then when found. You don't know when can you actually determine when she actually passed away or actually died?
death. No,
So you just place the time that she was found.
yes,
And then you go through your, the background, which is basically the information that we had just kind of ran through in a synopsis form of how she's found. The groceries are still left out on the, not being placed, put away. And then all the biographical information you all had received that night.
yes, that's correct.
And then in your findings, you go through the information that was presented to you that we just went through as far as the videos from Walmart, cell phone data, front door being unlocked, her wig being located on the floor near her body, and then the large gold diamond ring being sold on the auction, on the live auction site.
Yes, that's correct.
Also, there was a sale made on January 31st, including gold and diamonds at the Diamond and Gold Exchange, a local jewelry place.
Right, that's correct.
And then you went through all the videos again and the photographs from that night and changed it, and based on all of that information, you changed it to a homicide.
Right, there are some superficial entries that in and of themselves, you know, don't necessarily mean anything, but when you take into the aggregate of all the information, I was compelled to make a change in the ruling.
You had noted that she might have a bruise on her head, maybe on her wrist, things like that. Today, right now, we don't know when she might have gotten those bruises.
Correct. Yeah.
But you noted them as you would do, as a doctor would do.
Right,
And but the information that you drew upon are these findings and these things that we just talked about.
right,
And then on State's Exhibit number 321, you have homicidal violence as the reason for this homicide.
right, the cause of death.
Okay. And could that include smothering as well?
Yes,
And Dr. Bernard, we've already heard from Dr. Danielson, but you would agree that a pillow is a deadly weapon
it is, yes,
if it's used in this manner and this means?
correct,
And hands could be a deadly weapon if it's used in this manner and this means?
correct,
And then, but because we can't really tell for sure which object might have done this, then there are objects that could be unknown or unknowable to the grand jury in making this determination.
correct. You could have carpeting, it could be a variety of things, anything that you can obstruct the airway with.
I'll pass it on.
Mr. Warren?
Thank you. Excuse me, thank you, Your Honor. Good morning, Doctor. How are you?
Fine, thank you.
My name is Kobe Moore, and I represent Mr. Shamir in these proceedings. Your Honor, may I approach?
You may.
So, Doctor, you said you've been at Swift's for how long?
Well, since 1987, but I've been the chief since 1991.
Okay. And you've been the chief medical examiner, and then what was your other title, I'm sorry?
Well, it depends on which one you're talking about.
Current
As
one?
the director of Swift.
The director of Swift. And Swift, as we've heard about, it encompasses several areas up there. Is that correct?
Right, it's the medical examiner's office and the criminal investigation laboratory.
Okay. Let me show you, in regards to, every case that you have that comes into the Swift has a unique number, is that correct?
Yes, but this doesn't mean that only the cases that are brought to the office have a number. Every case that is reported to the office has a number.
Okay.
And so in this case, initially, it was not brought in, it was called in.
Okay.
And based on the information that was provided and the lack of anything at that time that was suspicious, the death certificate was relegated back to the treating physician.
Okay.
That's what the CB means.
Okay. And this case number, this IFS-18-02321, is consistent with the autopsy as well as the in absentia report besides the CD, is that correct?
Well, there wasn't an autopsy, but it correlates to the investigative report and then my absentia and inquest report.
Okay.
All the same number.
And have you seen this investigative narrative report, Doctor?
Yeah, I've got it sitting in front of me right now.
Okay. The gentleman offered defense exhibit number 1.
No objection.
All right, defense exhibit number 1 will be admitted.
Commissioner Publisher.
You may.
And Doctor, so I'm looking at defense exhibit number 1, like you stated, you have a copy of it up there. And this goes back, so explain to the jury what the investigative narrative is exactly.
Yeah, the investigative narrative, under Article 4925, certain cases are reportable to the medical examiner's office. And during that time, depending on what information is provided as to whether that case is brought into the office or the death certificate is relegated back to a treating physician. So let me just go over.
Yes, sir.
Unnatural deaths would end up with the medical examiner's office certifying. So only natural deaths would be relegated back to the clinicians if they're willing to sign the death certificate based on their treating.
And so, Doctor, in regards to an investigation narrative, does in these offices, do they receive that phone call from a law enforcement agency? Is that how that works? Or?
You know, we were called by a police officer contacting our office regarding the death of Mrs. Brooks, that she had been discovered dead at her residence.
And in that, like as we see in defense number 1, it kind of lays out the initial notification and how it came to be. It says Officer Shane Harris with Richardson Police Department contacted DCME, which is the Dallas County Medical Examiner. Is that correct?
Yes.
Okay. And that would have been by phone call in a situation like this. Is that correct?
Yes, sir, that's correct.
Okay. And basically in this report, it just lays out, Doctor, his findings, what he observed when he got there. Is that correct?
Yes, sir, it does.
And when you talked about when you received this information, and especially assessing your the information that you received after the fact in order to provide your in absentia report, you would go back and you would also look at this investigative narrative. Is that correct?
Yes.
Now, and the differences though between those, like some of the things Mr. Fitzmartin had asked you about that's contained in State's Exhibit number 293, like for instance under findings number 3, it says defendant's front door was unlocked when her grandson arrived to check on her welfare on January 31st, 2018. That information was also contained in that investigation narrative. Like Officer Shane Harris had that information on that night, correct?
He may have had it. I don't believe it's in this original report.
And you understand that, you know, as Mr. Fitzmartin pointed out, some of the evidence that the jury has seen was the body cam of Officer Shane Harris that night. You know, so it says then on number 4 that the decedent's wig was located on the floor near her body, which was also seen by the jury. But that's information that you used in your absentia report, is that correct?
Well, it's putting together all the information we had and putting it back together again to gain the totality of the impression that I had.
Correct. And then And were you also, let me ask you this, doctor, did you ever see those video clips of Officer Shane Harris's body cam?
I saw a body cam video.
Okay. Did you see the one where he, on his own volition, he decided to make further inquiry in regards to any injuries he may or may not have seen on Mrs. Brooks? Did you see that?
I think that we have in our report that he didn't see any.
Correct. So my point is, doctor, is that in regards to your in absentia report and the investigation narrative or the information that was actually received on January 31st of 2018, the only information that you received different is the information you received from law enforcement about some outside things, correct?
Other than the video that I saw, which would be me personally viewing it, but yes, it would be investigative information.
Okay. Now, so doctor, without those things, you would have continued to be filed and held as a natural death, correct?
Right, without investigative information to redirect our concern for the case, you're right.
Because nothing of the findings or medical findings or even the findings of the police department on January 31st, 2018 led anyone to believe otherwise, that it was just a natural death, correct?
Well, that's what was initially thought to be the case at that time.
And doctor, is it typical for findings such as these to be changed or altered just based on the fact of outside information, but nothing scientifically or medically found that would differ from the initial findings of the report?
That would depend on the particular case. So, I mean, I'm not sure I can really answer your question. I mean, we may get phone calls, we document it, and if it doesn't compel us to reevaluate the case, then it may be documented, but we don't change anything.
Because, I mean, you'd agree with me almost anything is possible, correct?
Well, that's a big question, so I guess I'd have to say about anything's possible.
So, like, there are other reasons why some of these things that you've relied on to make this in absentia report, they could be outside of the state's case in regards to jury being missing and things to that effect. Like, you've been around a medical examiner, you understand certain times someone may die, people may come in and say things prior to law enforcement arriving, family members have taken things. So there are reasons why certain things may be missing.
Well, in a general sense, that's a true statement.
Right. Thank you, doctor. That's all I have.
Any more questions, Dr. Bernard?
Yes, Judge. So Dr. Bernard, has the police in other cases, at other times, have they brought you suspicious activity and you've not agreed with them and made your own ruling?
Oh, yeah.
That happens all the time, right? Well, no, maybe not all the time, but it happens from time to time.
Well, I mean, they may come in with an opinion, and unless I feel like that I believe their opinion or the investigative information is compelling, I may not change anything.
Okay. And the defense exhibit number 1, in showing this is the report that was generated the night or the day after, or closely after the January 31st finding of Miss Brooks, right?
Correct.
And it's based on the information that was delivered basically over the phone to one of your medical examining investigators.
That's correct.
And at that time, we can see in here the scene observations. And it's basically the same thing that you've got in your in absentia report about what Officer Harris viewed that night, correct?
Correct.
And then it goes through the medications and then other information that's found. And it talks about the groceries being out. And it talks about the state of her body and that there's a little bit of blood coming out of her nose and things of that nature, right?
Right.
But there was nothing at that scene, nothing left behind that 3 experienced police officers would look at and determine that someone had done something of foul play.
That's correct.
Had they had that inkling, had they thought that something had been left behind or something looked suspicious, would you have then sent someone out and the medical examiner's office treated it differently?
Well, in this case, it was after, I believe, a daughter came in and identified that there was something missing in the house, that then she filed a report. Had we had that right off the bat, had someone, the grandson who found her, said that there was a missing safe or whatever was missing, we would have probably not only sent someone out, we would probably brought the case in.
And don't you think the police would have treated that a little bit differently as well?
I think so.
And are there unattended deaths of elderly individuals in Dallas all the time, or a lot of the time?
Well, we have somewhere around 9,000 or more cases that we don't bring in, because otherwise we would end up with like 15,000 cases coming in the office. That's untenable. No office can handle that. So you have to make decisions based on those cases, the findings, and the medical history of which cases rise to the level that they need to come in to be examined.
So the scene as it was left that night left the police, experienced police officers, to believe there was no foul play, and therefore you all had to treat it the way you would a normal situation where an elderly individual had passed away.
That's correct.
And then later on, as things develop and as information becomes known and suspects are developed and more information is gathered, you can then go back and reassess the information you had on the 31st and maybe call it a different way like you did in this situation.
Yeah, we've done that not only in this case, but in previous times since I've been at the office.
I'll pass it on.
Nothing further, Your Honor.
All right. May Dr. Bernard be released?
Yes, Judge.
No objection, Your Honor.
All right, you may step down. Thank you, Doctor.
Your Honor, ladies and gentlemen of the jury, the state of Texas rests its case in chief.
Thank you so much. So at this time, can I see the lawyers at the side? Okay, ladies and gentlemen, with the state having rested its case in chief, this will be a good time for us to take our lunch break. I will give an extended lunch today, so if you would be back in the jury room at 1:30, push your button, and we'll know you're there, and we will proceed with the rest of the case.
All right.
It's live stream, this part.
Okay,
Okay,
okay.
you can start over. Go ahead.
Oh, Okay. We,
Judge, could I put one back in?
Yes. We are back on the record in cause number F1875401, outside the presence of the jury. There is a motion that the defense wanted to put on the record.
That's correct.
Mr. Warren, you may proceed.
thank you, Your Honor. Your Honor, at this time, after the state of Texas has rested its case in chief against my client, Mr. Billy Shamirmir, we're going to ask the court, we're moving the court to enter a directed verdict on behalf of Mr. Shamirmir based on the fact that the state of Texas has failed to make a prima facie case, proving its case on each and every element that they've alleged against Mr. Shamirmir in this cause and in this indictment, Judge. And we respectfully, this time, ask you do so.
And that motion will be denied. And we are off the record.
Murder, burglary of a habitation, and theft. And the state would request that the defense make a proffer of what the evidence is that they believe would entitle them to those lessers.
Mr. Warren?
Well, Judge, I believe that, well, the defense, we believe that there's been evidence presented that if the jury did not believe that, as we all know, the capital murder is murder plus. And so if the jury did not believe one of those allegations that are contained, and I believe in the indictment it is
No burglary, no robbery?
correct. If they, then theoretically, they could believe that it was just simply murder. They also, if they don't believe that he murdered, then it would be an acquittal if it wasn't the murder in either of those, burglary or the robbery. Also, in addition, there's been evidence submitted before this court, before this court as well as this jury, that if they didn't believe any of those things, however, they did believe that he was in possession of stolen property, then a theft could also be applicable here, Judge. So we believe there's been a scintilla of evidence that's more than sufficient for our lessers to be included in the court's charge, and we're going to request such, Judge.
So the lessers you're requesting is murder?
Yes, Your Honor.
And theft?
Yes, Your Honor. Burglary?
So you're burglary?
Yes, Your Honor.
So you're asking for murder, burglary, and theft,
And robbery.
and robbery?
Okay.
What about, it would at least be
Yeah.
aggravated robbery, I mean, aggravated robbery.
Well, so here's the deal. There is absolutely no evidence that the defendant was there and murdered the victim but didn't rob her. It's the exact opposite. In his statement that was played for the jury, he said, "I was not in that house. I did not kill anybody." So we have no evidence showing that it was just a murder and not a robbery. Same with the Burke Hack. I was not at that house. There is no evidence that he was just there and he robbed her, but he went into her house and stole from her but didn't kill her. So the state believes, I think we'll agree with the theft, because I think in his statement he did say that he did agree or did believe that potentially the jewelry box that he bought from this unknown man could have been stolen. so we're not objecting to theft, but I just really don't think there's any evidence before the jury that would say, if he's guilty only of murder, or he's guilty only of burglary.
And Judge, in reply to that, in regards to even going on with Ms. O'Connor stated, was Mr. Shamir's statement that if he bought that property knowing that it was stolen, that it could be stolen and it could have been burglarized from Ms. Harris's home. And so we would ask that there could be a party, he could be a party to it, Judge. So it's up to the jury to make that decision.
But there's no evidence that he solicited, aided, encouraged, did anything in furtherance of a burglary that would make him a party to that offense.
And then he would then be a party to the capital murder, bringing us all back to where we are with just being a capital murder.
So just so the court is clear, the state of Texas is saying that basically in our dummied down summarized version, you almost got to admit it to get it, right? You have to either admit you were there, around, participated, blah, blah, blah.
Right, even in their cross-examination, they're not admitting that's his car, they're not admitting that he's in possession of the cell phone, they're just saying, that's his phone number, that's his device, but we don't know who has it. Yes, he has a car like that, but we don't know that he's driving it. So they're denying all of the things that we're trying to prove up to show his presence with the victim at the scenes, those things. So if they're saying he's not there with the cell phone or he's not in the car, then how are they going to say he's at the house? He's already told everyone that he was not at the house.
And in fairness, the defense is requesting that although he may be in possession of items that he does not know where they came from, that could possibly make him a party
To, at a minimum, the burglary, Judge.
to the burglary, but not the...
Right, no, we don't, Judge, we don't have to prove how that occurred.
You're correct.
But if they're alleging that that property was taken from Ms. Harris, so from her home without permission, in and of itself, that's a burglary. Someone did that.
Okay.
And so he has that property. And so if there's evidence or there's an argument that can be made that in him receiving that property that was burglarized from Ms. Harris, that he's a party to it.
But you have to
It
have
didn't
knowingly
have-
or intentionally done that.
And it also didn't have to be a burglary for him to have the stolen property.
How do,
I mean, what's the connection to that?
You're alleging it was taken at some point from her home without her consent.
We're alleging it was taken from her, yes. I mean, in terms
From her-
of,
from her
it
home.
was stolen from her, so that's a theft.
Yeah, that's that. Which the defense and the state have agreed that would be theft under the scenario that you're giving, Mr. Warren. Those elements, I guess I would call them, would be theft. It could be theft of, stolen property. It could be a theft by any number of ways. So everybody agrees that it's a possibility that it's theft, or as we like to commonly say, maybe some hot goods were purchased. So everybody is in agreement with the theft.
Yes, Your Honor.
So the contention is the defense wanting a lesser of burglary and murder. I think we kind of canceled out the lesser of murder. Correct? We go by the law.
If that's the court's ruling, then yes. But we would still request it, just request a ruling on it.
Okay. So, and I will do further research. So the defense wants a lesser of theft, a lesser of murder, and you wanted the lesser of burglary
And aggravated robbery.
and aggravated robbery.
And it's up to the judge, and we can request it and you can deny it. It's that simple. Like, we don't have to.
Yeah.
And I mean, our arguments would be the same as to aggravated robbery or robbery. Again, like if there's no, if his position is I wasn't there, I didn't go in the house, I didn't harm her, I didn't, what would be the deadly weapon in an aggravated robbery? The pillow. Again, it would be capital. It wouldn't-
Let's ride that horse. Absolutely not. Let's ride that horse.
So our position would be the same as to
Okay.
ag rob, and burglary.
Okay.
In terms of the evidence that's been presented, we don't think it rises to level 2 entitlement to that
Okay.
those lessers.
So is there any particular statute of, any particular subsection of the theft statute that you are considering?
I think,
Oh, yeah, we did talk
Code
about that,
Criminal
Judge. So
Procedure
we
31.
did talk about 3103B,
31?
and I think we
it's
agreed,
30, initially I'd said 31
You said
C3.
initially.
C3,
which
right?
applies to like pawn shops and things of that
Yeah.
nature, but I think that we've just agreed we're gonna go under 3103.
B?
Yes, Your Honor.
And
Okay.
then, the amount is the 750 to 2,500, which would be a class A misdemeanor. I mean, technically, We haven't offered evidence of
The value.
the value, but that's what the parties have agreed that
Yeah,
we're
Well, at
this
comfortable
point-
in submitting to the jury.
of the testimony evidence we've seen.
And Judge, we object to any reference of any misdemeanor language. I mean, it can track the misdemeanor language, but if the court decides to include the misdemeanor language, that it will not be referenced, this is a misdemeanor. It's not relevant that the jury know that.
Well, once we get to that decision, it is a punishment range that they will have to know about.
No, Judge,
But only if we get to the
you're
punishment phase.
Decider, we're going to you for punishment.
With the lessers, gotcha. All right, so,
Wait,
theft,
so I just,
burglary,
It would say
aggravated robbery. Go ahead.
it would say in the charge, in the verdict form of the Class A misdemeanor
No.
theft or the state jail, right?
No.
I'll have to pull up one, I'll have to find out, but if I'm not,
I think
know,
we're agreeable to that. We
Yeah,
won't
yeah.
include the,
I think what you're thinking of, Glenn, when it's the original charge, I have to put the punishment range, but the lessers, it does not lay it out, Class A, Class B, it'll just, if you find that person.
the difference though, Judge, is that normally the jury would be more dire on the different ranges of
Exactly.
punishment for all their thefts, and because we didn't do that, they have no idea that there is a wide range from a misdemeanor all the way up to a felony, depending on the value of the
And I would go one step further and say that we're going to first address the guilt innocence
And-
jury charge.
Correct, and more
If
importantly,
we were to get the punishment, this would go into a punishment jury charge.
if,
There is no
if,
punishment
if
jury
Mr.
charge.
Shamir had not elected
If he is found
to,
guilty of the
But it-
lesser, Mr. Watson, it would be a punishment.
but he's
We are
elected,
going to you.
yeah, we've elected to come to the
Okay,
court.
all right, you're right.
Yeah. So it's not relevant. No, I don't.
You don't want to admit that?
That's not necessary right now.
Anything further in
No.
regards to the guilt innocence?
None from the defense, Judge.
I've been reviewing Mr. Watson's edits, and so I'm almost done with that. There are a few that I can agree to, so I was just gonna make those corrections, and then whatever lessers the court rules on, we'll add those in, and then we can have a final version for everybody to review. There are a few of his edits that I'm not agreeing, or that we're not agreeable to. Did you want to do those now, or you want to do those after lunch?
We can do them now.
Let's do them now.
Okay. Do you have
I have a copy of his.
of his?
Where's yours?
Right here.
Okay. Wait, which one is?
Wait, you didn't offer this. Do you want to offer it?
Yeah, that's fine. Judge, for purpose of the record, we'll offer defense exhibit number 2, which is just our version of,
Is our request to jury instructions.
okay.
And it's basically, Judge, they took the Word document that we sent them, and then Mark used the editing tool within Word and added or deleted certain things that they were requesting.
And Judge, this is an incomplete one, but it is a version of, because this one does not contain theft in it,
Okay,
but we will offer defense exhibit 2 for the purpose of the record. Yes, Your Honor.
and does the state have any objection?
Not for record.
Okay, so defense exhibit number 2 will be admitted for record purposes. Thank you.
And Judge, if we can just go by this page by page, if that's okay with you.
That's fine.
Okay, so on page 1, the proposal is, it did say, and you were instructed that you may read these instructions as a whole. They're proposing to change it to say that you are to read and follow these instructions as a whole. We would object to that language because the case law says that they may read it as a whole, but it's not a mandatory instruction that's to be given, and so we don't feel like that's consistent with the case law.
Okay.
Mark, did you want to?
Judge, we just stand on our submission.
Okay. And I'm just taking notes and then we'll,
Okay. And then, moving forward,
I'll tell you what, Judge, I do want to comment on that. I submit to the court that for the whole purposes of our argument regarding jury charge, that the pattern jury charge of Texas is suggestive. It's not mandatory on the courts, it's not binding.
the courts can use any approved or anything that is, that the court decides that it has been used in the past, and it is not error to use another version. And that's some of the language that we've used. And then also some of the language we have put in here is in the pattern jury charge.
Okay, and those are, yes, got it. And I would agree with that. However, what I was citing to is the actual case law from the Texas Court of Criminal Appeals, which she is bound to follow, does not use the word must, it uses the word may. And so it's a permissive, it's not a mandatory instruction that must be given. Okay, and then on page 6, there was a request to add the language, and you further find beyond a reasonable doubt. We're not objecting to that, and I've already added that language in. And then additionally, they're asking for us not to use the term the deceased. They wanted to use the victim's name, Lou T. Harris, so I did make those changes as well. We're agreeable to that. And then we're obviously objecting to these lessers, as we've stated, so that'll be for the court's ruling. I do have proposed versions of the lessers, if the court is inclined to give them any of the lessers, and so I guess we can iron that out when the court makes its ruling. I would agree, I would definitely object. On page 8, he has these separate paragraphs in bold, where it's if you have a reasonable doubt as to whether he committed a specific offense, and they're singled out. And I don't feel like it's proper for the court to single those out. We usually do that in one paragraph where you say, you know, if you have a reasonable doubt, if he's guilty of the greater offense or any of the lessers, you resolve that in his favor. So this is basically instructing them
To separate them out.
yeah, and it's calling attention to them, and it's directing them to find him not guilty of capital murder, which goes against this concept that they're to read it as a whole and decide at the end. So we would object to that.
Your Honor, may I respond?
Yes.
That bold print is, that's not, that was put in there. I did it by my computer. It wasn't intentional, or it's not intentional. And we are more than happy to put that in regular type without the bold print.
Okay, thank you. And anything further on 8?
No, Your Honor. And I think that would be the end of it. There's no, as far as I can tell, there's no other suggestions on pages 9 through 14. And then, of course, obviously, the verdict forms will be amended to add whatever lessers the court decides.
There was one on 9 that you were okay with that? If you do not so find, or if you have a reasonable doubt?
Oh, yes, that language, so that wasn't included in the original version because there were no lessers, and so when the lessers go in, there's that instruction that's like, if you do not so find, you will next consider this one, and then you will next consider this one, and then at the end you say, you basically instruct them that if, you know, if they can't agree as to which, they must resolve that in his favor.
Yes.
Or acquit.
So I've seen on 10, 11, 12, and 13.
Your Honor, we are asking for the language, if you have a reasonable doubt whether or not the defendant committed the offense of capital murder against Lou T. Harris, you will next consider whether or not the defendant committed the offense and whatever lesser included you put in.
Yes, that's pretty much standard. So that will be in there. All right, so this is what I have. I have, based on the document that I have received, which is Defendant's Exhibit Number 2, that there is an objection by the state on page 1 in regards to adding the language of may read these instructions. Is that correct, Ms. O'Connor?
The original version said you may read these instructions as a whole, and they're asking to say that you
Oh, that's right, are to be read.
right, and so we would be objecting to that mandatory language. We would just ask that it be instructed that they may.
Gotcha. And the next objection by the state would be on page, well, actually on page 6, everything is agreed to, correct?
Yes, Your
On
Honor.
page 6, okay? On page 7, the state has objected to the language or the, I don't know how which.
We're not objecting to the transition language where it would say, if you do not find beyond reasonable doubt, or if you cannot agree, you will next consider whether the defendant is guilty of, and then whatever the lesser would be. We don't object to that transition language, but we are objecting to the requested lessers,
Okay.
other than that.
That's what I needed to hear, yes. Okay.
And Mark, that paragraph that you're requesting on the bottom of page 7, did you pull that from a pattern jury charge?
Yes, it's in three, well, I got it out of a yes. I don't know. I can find it in a minute.
And would you want that at the bottom of all the lessers, or like after capital murder but before the lessers?
I would like it in the bottom of all the
Kind of like where it would instruct them what to do when, like kind of at the bottom where it's telling them, you know, you have to resolve it in the defendant's favor. And
Yes.
then, okay.
Yes.
Yeah, we won't object to that, Judge. The bottom of page 7, it is not necessary for you to acquit the defendant of the greater charge in order to consider a lesser offense contained in the charge.
No,
Because that's consistent with telling them they can read it as a whole.
Yep.
And then, do you agree or you disagree with the language? If you are unable to reach an unanimous verdict regarding the charge of capital murder, you are instructed to resolve that issue in favor of the defendant, and next consider the offense of XYZ.
Yeah, that's them objecting to the lessers, right?
Are you talking,
Or you just saying the
are you
language?
talking about the top of page 7?
Yes.
Just that transition language?
Uh-huh.
Basically, like if they're not able to agree, if they don't believe beyond reasonable doubt, or if they're not able to agree. I like to include that language. It should say, if you do not believe beyond a reasonable doubt, or if you are unable to agree, you are instructed. Well, I don't know that you can tell them at that point to resolve it, because they're supposed to read the charge as a whole. So I think you should just say you will next consider the lesser offense of, and then whatever that lesser would be.
Okay.
So everybody's, so we are in agreement of the transitional language on the page, top of page 7, or?
Well, I don't think that it should
Maybe
say
in-
you're instructed. Judge, how about this? Over the lunch break,
Yes.
I will make the changes that we agreed to, and I will give the proposed charge to Mark. And he and I can iron all this out, and then that way you're not having to, would that be agreeable to the court? And like, so the things that we agreed to, I'll add them in,
Okay,
and then that way we're only talking about the language that we're objecting to, that, as opposed to like going line by line.
yep, I think that will work, because the only other one that was left was page 8, and that is the objection to the lessers, so I get that. Yes. Okay,
And then just there's one more thing in regards to the charge itself. The defense would move the court to instruct the state to elect to which paragraph that they are proceeding under. There are two very distinct methods in which they've charged Mr. Shamirmir, one being capital murder with burglary, the other being capital murder with robbery. And we believe that a jeopardy issue would attach in regards to the way that they alleged it, and it would be a violation of his 5th, 6th, and 8th Amendment rights. And so we'd ask that, and move this court to instruct the state to elect which paragraph they would proceed under.
your response, Ms. O'Connor?
Judge, we're allowed to allege multiple manner and means of capital murder, and the jury doesn't have to be unanimous on which one of those. 6 can believe it's burglary, 6 can believe it's robbery, and so there is no requirement under the law, and it's also not a violation of any constitutional rights for us to include all those manners and means in the jury charge.
All right, thank you. At this time, the defense's objection and request will be denied and overruled in regard to making the state elect which manner and means that they want to choose, or which paragraph. Anything further from the defense?
I don't think so, Judge, at this time.
All right, anything further from the state?
No, Your Honor.
All right, well, we are officially at our lunch break, which is 12:40. Well, let me see the lawyers up here real quick.
Keep it on, Billy, come here.
You just know he's married. Crystal, we're off the record. Okay. are back on the record in cause number F1875401, and we are at the charge conference. Each side has received a copy of the court's charge, and just to make it simpler for everyone to be aware of what changes were and were not made. So if you flip with me to page 5, what is different is that actually at the bottom of page 4 and the top of page 5, I have removed the actual definition of person acts knowingly or with knowledge with respect to the result of his conduct, because in the indictment it is alleged as intentionally.
It's still in mine, Judge.
Is it still?
Wait,
You
can you have a
right?
staple copy, Kobe?
Well,
I just have mine, it's in mine too, the second
Does the
paragraph.
person act knowingly?
or not. But you would need that for theft anyhow.
right.
Well, we have the definition in there, but I will tell you where, let me make sure I'm looking at the right copy. So we say the following definition apply to the offense of burglary, robbery, and theft. Yeah, it's still in there for theft, but we took it out. Okay, so you know where it says mental state? The following definitions apply to the offense of capital murder. See that at the bottom of page 4?
It's on mine, Judge, right below intentionally.
Let me see yours.
Mine was the
You may have printed the wrong one. Yep, okay. So,
We
I
can,
will go put the correct one.
we can just mark that out. You want to tell us, is there
Yeah,
anything?
I'll tell y'all what the changes are, and then I
Okay.
can get you the clean copy.
Okay.
So, bottom of page 4, top of 5, however I see it on y'all's a little different. So, the language, a person acts knowingly or with knowledge with respect to the result of his conduct. When it comes to the definition of capital murder, as it's alleged in the indictment, it is alleged as intentionally. So, does that make sense? That definition is taken out? All right.
So you're taking out those 2 lines.
Yes, for for under capital murder only. And then if we go to page 6, where we have the application paragraph that does talk about capital murder, just simply took out the words knowingly. Because, once again, indictment says intentionally. All right. On the other place, also the change that Mr. Watson wanted, that remains. I did not take that out. And the only other thing is, so when I got the updated verdict forms, it still didn't have the or. So we just put the or in. But other than that, that's the only changes. It's just basically to the application paragraph of capital murder and to the definitions of defining the mental states in capital murder. Does that make sense to everybody?
Yes, Your Honor.
Okay.
So you have no objections, Your Honor, to the charge?
Defense?
Judge, just what we submitted to the court in the defense exhibit number 2.
Okay.
So we object, we object that we didn't get all that we asked for.
All right. So for the record, the defense objection for the record during the conference charge is that they have requested the lesser included of burglary as well as the lesser included of robbery and the lesser included of murder. Given the facts, evidence, and testimony, the court denied that request. However, there are some other items that the defense requested be included in the charge, which were included at the behest of the defense. So, is there anything else in regards to the charge? State?
Nothing further from the
All right.
state.
Defense?
Your Honor, briefly, the defense has a motion in limine that the state not allude to or mention that the offense of theft is a misdemeanor or carries a lower punishment. That's the court, as we have elected that the court is going to assess punishment in the event it becomes a punishment hearing, that we've elected for the court to do it. It's not relevant, and it could and probably would influence their verdict if they if they were informed of the consequences of this verdict.
All right. That will be granted. I don't see that there should not be the necessity of discussing any punishment languages other than that which is charged in the court's charge. So that will be granted, Mr. Rice.
Thank you, Judge.
Anything further from the state?
Yes, Judge. Give me 1 second.
Okay.
Judge, at this time, we will offer State's Exhibits 322, 323, 324, and 325. These are pictures of the boards that we've been using throughout this trial as demonstrative purposes. So 322 is for January 30th, 323 is for March 15th, 324 March 19th, and 325 is March 20th. And we'll offer these for record purposes.
For record, no objection, Your Honor.
All right, states 322, 323, 324, and 325 are admitted for record purposes, or did you say all purposes?
Record.
Okay, for record purposes. Okay. Okay. Make sure that. Let's see if I have it correctly. I printed off two. So, I will go print, how many copies do y'all want to need?
You don't even have to reprint mine, I'm sorry.
Okay, well, I'll just go print the one for the court,
Okay.
to get marked, okay.
Well, you know what, Judge, I think we will take one copy then, if
Okay.
you
Okay.
are going to.
All right, we're off the record, Crystal. from lunch, ladies and gentlemen. I hope you enjoyed it. We are back on the record in cause number F1875401, which is the state of Texas versus Billy Shamirmir. We left off with the state of Texas had just rested their case. It is now the case of defense. How would you like to proceed, Mr. Warren?
Your Honor, ladies and gentlemen of the jury, the defense will rest.
All right. State of Texas.
State closes.
Defense also closes, Your Honor.
All right. So, ladies and gentlemen, we have come to this moment in the trial where both sides have rested and closed their case. So now you will hear the court's charge, which is the law that you will have to follow during your deliberations. And I'll remove my mask so y'all can hear me more clearly. Cause number F1875401, style the state of Texas versus Billy Kipkori Shamirmir. Court's charge. Members of the jury. The defendant, Billy Kipkori Shamirmir, stands charged by indictment with the offense of capital murder alleged to have been committed on or about March 20th, 2018 in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. The following instructions are the law applicable to this case. You are instructed that you may read these instructions as a whole. Offense definitions. A person commits murder if the person intentionally or knowingly causes the death of an individual. A person commits capital murder if the person commits murder as that term is herein defined, and the person intentionally commits the murder in the course of committing or attempting to commit burglary or robbery. A person commits burglary if without the effective consent of the owner, the person enters a habitation and commits or attempts to commit a felony, theft, or an assault. A person commits robbery if in the course of committing theft, as that term is herein defined, and with intent to obtain or maintain control of the property of another, the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits theft if the person unlawfully appropriates property with intent to deprive the owner of the property. Term definitions. Actor means a person whose criminal responsibility is an issue in a criminal action. Another means a person other than the actor. Appropriate means to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent or the property is stolen and the actor appropriates the property knowing it was stolen by another. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended. Bodily injury means physical pain, illness, or any impairment of physical condition. Deadly weapon means anything that in the manner or its use or intended use is capable of causing death or serious bodily injury. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether expressed or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by force, threat, or fraud. Felony means an offense so designated by law or punishable by death or confinement in a penitentiary. Habitation means a structure or vehicle that is adapted for the overnight accommodation of persons and includes each separately secured or occupied portion of the structure or vehicle, and each structure pertinent to or connected with the structure of or vehicle. In the course of committing theft means conduct that occurs in an attempt to commit during the commission or in immediate flight after the attempt or commission of theft. Individual means a human being who is alive. Owner means a person who has title to the property, possession of the property, whether lawful or not, or a greater right to possession of the property than the person charged. Person means an individual. Property means tangible or intangible personal property, including anything severed from land or a document including money that represents or embodies anything of value. Possession means actual care, custody, control, or management of property. Steal means to acquire property or service by theft. Mental state definitions. The following definitions apply to the offense of capital murder. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious, objective, or desire to cause the result. The following definitions apply to the offenses of burglary, robbery, and theft. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious, objective, or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Capital murder. Now bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about March 20th, 2018 in Dallas County, Texas, the defendant, Billy Kipori Shamirmir, did intentionally cause the death of Lou Ty Harris, an individual hereinafter called deceased, by smothering the deceased with a pillow, a deadly weapon, or with hands, a deadly weapon, or with an unknown object, a deadly weapon, the exact nature and description of which is unknown and unknowable to the grand jury, and you further find beyond a reasonable doubt that the defendant was then and there in the course of committing or attempting to commit the offense of burglary of Lou Ty Harris, then you will find the defendant guilty of capital murder as charged in the indictment. Or, if you unanimously find from the evidence beyond a reasonable doubt that on or about March 20th, 2018 in Dallas County, Texas, the defendant, Billy Kipori Shamirmir, did intentionally cause the death of Lou Ty Harris, an individual hereinafter called deceased, by smothering the deceased with a pillow, a deadly weapon, or with hands, a deadly weapon, or with an unknown object, a deadly weapon, the exact nature and description of which is unknown and unknowable to the grand jury, and you further find beyond a reasonable doubt that the defendant was then and there in the course of committing or attempting to commit the offensive robbery of Lou Ty Harris, then you will find the defendant guilty of capital murder as charged in the indictment. If you do not so believe, or if you have a reasonable doubt thereof, or if you are unable to agree, you will then consider whether the defendant is guilty of the lesser included offense of theft. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about March 20th, 2018 in Dallas County, Texas, the defendant Billy Kipori Shamirmir did then and there unlawfully appropriate stolen property, to wit a red jewelry box and jewelry of the value of $750 to $2,500, the said property having been stolen from Lou Ty Harris is unlawful, its lawful owner, and the defendant acquired said property knowing that it was stolen property, then you will find the defendant guilty of the lesser included offense of theft. If you do not so believe, or if you have a reasonable doubt thereof, you will follow the following instructions. If you should find from the evidence beyond a reasonable doubt that the defendant is guilty of the charged offense or of a lesser included offense, but you have reasonable doubt as to which offense he is guilty of, then you should resolve that doubt in the defendant's favor and find the defendant guilty of the lesser offense. It is not necessary for you to acquit the defendant of the greater charge in order to consider a lesser offense contained in the court's charge. If you believe the defendant is not guilty of any offense or have a reasonable doubt thereof, then you will acquit the defendant and say by your verdict not guilty. Presumptions and burden of proof. In all criminal cases, the burden of proof is on the state. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless you are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. The state has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. This burden rests upon the state throughout the trial and never shifts to the defendant. If the state fails to meet its burden, you must acquit the defendant. It is not required that the state prove the defendant's guilt beyond all possible doubt. It is required that the state's proof excludes all reasonable doubt concerning the defendant's guilt. In the event that you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit the defendant and say by your verdict not guilty. Evidentiary instructions. You are instructed that you are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right by any word or any act to indicate any opinion respecting any matter of fact involved in this case, nor to indicate any desire respecting its outcome. The court has not intended to express any opinion upon any matter of fact in this case. And if you have observed anything which you have or may interpret as the court's opinions upon any matter of fact in this case, you must wholly disregard it. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might properly be admitted. Do not be concerned with the reasons for such rulings and draw no inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court does not determine what weight should be given such evidence, nor does it pass on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you of course must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. You are instructed that you may consider all the relevant facts and circumstances surrounding the alleged killing and the previous relationship existing between the defendant and the deceased, if any, together with all relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the offense alleged in the indictment. You are instructed that if there is any testimony before you in this case regarding the defendant's having committed an offense other than the offense alleged against him in the indictment in the case, you cannot consider that testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense, if any was committed. And even then, you may only consider it in determining the motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident, if any, and for no other purpose. You are instructed that the defendant may testify in his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as a circumstance against him or prejudice him in any way. The defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. Concluding instructions. It is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. In deliberating on this case, you are not to refer to or discuss any matter or issue not in evidence before you. and you are not to talk about this case to anyone not of your jury. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive and to follow the law from the court. After you have retired to consider the verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with the court in writing signed by your presiding juror through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any questions you may have. After argument of counsel, you will retire and select one of your members as your presiding juror. It is the duty of your presiding juror to preside at your deliberations and to vote with you in arriving at a verdict. Your verdict must be unanimous, and after you have arrived at your verdict, you may use one of the attached forms by having your presiding juror sign the particular form that conforms to your verdict. And it is signed by me, Judge Raquel Rocky Jones, presiding judge of 203rd Judicial District Court, Dallas County, Texas. And you will see on the back page there are 3 verdict forms. There are 3 forms. The very first verdict form says, "We, the jury, unanimously find the defendant guilty of capital murder as charged in the indictment." It is a signature line for the presiding juror and then a line for the presiding juror to print their name. Or the next verdict form. "We, the jury, unanimously find the defendant guilty of theft as included in the indictment." A signature line for the presiding juror and a printed line for the presiding juror to print their name. Or there's a verdict form that states, "We, the jury, unanimously find the defendant not guilty." There is a line for the presiding juror to use their signature, and then there is a line for the presiding juror to print their name. State, are you ready for closing arguments?
Yes, Your Honor.
Defense, are you ready for closing arguments?
Yes, ma'am.
All right, Mr. Varney, you may proceed.
Thank you, Your Honor. His greed was more important to him than the life of Lou Harris. That's what the evidence has shown over these past few days. The judge read the charge to you, and all of it goes towards what is alleged in the indictment, that the defendant took the life of Lou Harris during the course of robbery and or burglary. You're not going to read that court's charge and see the name Mary Bartell or Mary Sue Brooks. But the law allows us to put on that evidence, and it was important for you to hear what happened to those 2 women. Why was it important? It's important because it shows that this isn't just a coincidence. If you just had the Lou Harris case, you might be tempted to say, well, maybe he just had her stuff, and that she died or someone killed her, and that he just happened to have her property with him. But because you have the cases of Mary Bartell and Mary Sue Brooks to go along with it, you know now that when they were shopping in that Walmart, when they were running their errands, he was in his hunting grounds. You know now, because you've heard of all 3 women in their situations, that he picks out women he thinks are too weak to resist. You know now that to him, the women who are matriarchs, who are grandmothers, who are focal points of a family, to him are just walking dollar signs. And that the jewelry that they wear that represents love and life and memories, to him is just a way to get some quick cash. So think about when you're deliberating, how in the world is this a coincidence? When you have 3 different women who don't know each other, who don't know him, that Miss Bartell ends up attacked, left for dead, but thank God she lived. Miss Brooks killed in her home, and Miss Harris killed in her home. And the only really common factor among all 3 is that every time they're at Walmart, he's there, and that he's outside their house, and that their property ends up sold or about to be sold. It's interesting when the judge reads the court charge and she says, you're allowed to take in any facts and circumstances regarding the relationships of the parties. And we know there's no relationship pre-existing between any of them. But think about his statement to Detective Tabor. Remember we watched that hour-and-a-half video of him talking to Detective Tabor? Think about this. When Detective Tabor says, Billy Tremere, you are charged with murder. Did he even ask who died?
Did he even want to know the name of the person who died so that he could say, wait, is it my neighbor? Is it someone I've come into contact with? He just says, no, I've never been anywhere. Never been at Preston Place. Never been near Luke Harris's home on Warm Breeze. He didn't even think to ask who had died. Wouldn't that be normal? To say, wait, you're charging me with murder of who? That's what a sociopath is, who is so easily able to separate what he's done from himself that never even comes into his mind. You have the opportunity now to tell him through your guilty verdict that we don't buy your act. We know that this quote-unquote Mexican guy in a white truck doesn't exist. We know that you were in the Walmart with Lou Harris, just like you were at the Walmart when Mary Brooks was there, just like you were outside the home of Mary Bartell. We know you were at Lou Harris's house because your phone records show it. We know that you were at her house because you ended up with her keys and that the house was locked up when the police show up. Remember, when the police got there, they couldn't get into the house. There was no opportunity for anyone to come back and say, well, the door was just swinging wide open, so maybe someone killed her, left the door open, and he came by later and got the property. That house was locked up so much that they had to go find someone to get in. Remember in jury selection we talked about who controls the evidence. And remember that one of those prospective jurors said the person who did it controls the crime scene. He had controlled it to the point where if that attack on Mary Bartell had not happened, who knows when they would have found Miss Harris. It was only because she was attacked that they said, hey, we need to go figure out who's doing this. And that they worked their way backwards from that name tag, remember, William Bill Harris, back to the home of Lou Harris. You can tell them by your verdict that we know that just like with Mary Brooks and Mary Bartell, if the police had not caught him discarding this jewelry and throwing stuff out at the dumpster, he would have been right back at Dallas and Gold Exchange just like he was in their two cases. Seemed like a lot of money right over time, $91,000 in transactions. That's the kind of money you can make if you don't have a job and all day you're out just hunting for someone to take advantage of. The judge read the court's charge to you, and we talk about burglary and robbery. Don't get hung up on that. Don't get caught up in, well, some of us think it was burglary, some of us think it was robbery. We talked about in jury selection that 6 of you can believe it was a killing in the course of burglary. 6 can believe it's killing in the course of robbery. Still guilty either way. Okay? More likely, all 12 of you will believe it was burglary and robbery. That's okay too. But we know what it's not is theft. We're not here for a theft case where he just happened to receive some stolen goods. Well, it was just a coincidence. Just every time Billy ends up having somebody's jewelry, someone else killed somebody and they sold it to him. That's great if the defense wants to get up here and argue that, but I will submit to you there is no piece of evidence that proves that at all. There is no piece of evidence that shows he just has the property and he was never connected to those people. Remember those boards we had this morning and the pictures start going up? And it says, okay, well, his phone says he was here. Well, now we have a video of him there. His phone says he was over at Dallas Gold Exchange, but we have the receipt showing he was there. All that goes to show that the evidence is credible. That path and that pattern is shown, that every time he finds a victim, he finds someone that if someone finds her dead, they're just going to think, well, she was 87. Things like that happen. Maybe she fell. Maybe her heart gave out. But then it's just like clockwork for him. Kill the person, attack the person, immediately go try to turn that over for a little bit of money. You're going to hear a ton about beyond a reasonable doubt, beyond a reasonable doubt. We have given you more than that. We have given you beyond all doubt. We have given you an investigation that spanned Richardson, Plano, and Dallas, that was detailed down to the people involved in the transactions with Billy Shamir, down to the people who recognized the jewelry of their relative to say, yes, this belonged to her. This was important to her. She wasn't going to give it away. She wasn't going to lose it. I mean, you heard about Mary Brooks keeping her stuff in a safe, and the whole safe was gone. You heard it was important to them, and that it was part of their legacy. He took that away because of what I said earlier, because of greed. That his greed was more important than their lives. We're going to ask that you go back, if you need to, look at the court's charge, but I submit there's nothing in there that should give you any trouble, because all of that court's charge says is this: if you believe he took Miss Lou Harris's life in the course of taking her stuff, then he's guilty beyond a reasonable doubt. We ask that you go back there and you deliberate, you work together, and you come back with a quick verdict that says, we know you're guilty. We know you picked her out. We know that her property was more important to you than her life. And you won't be telling the defendant anything he doesn't already know. Look forward to your verdict.
Thank you. Defense will be making the closing statement.
Thank you, Your Honor. Please, court.
You may.
State. Afternoon, ladies and gentlemen. Let me first start off just by thanking you guys for the time and attention that I've seen you put forth during these last few days. I've watched you listen intently. I've watched you pay attention to things. And I want to thank you because without citizens like you, this entire process doesn't work. And so I thank you on behalf of my client, Mr. Shamir, and for the entire system. So before I jump into what we want to describe as the meat of my argument, I want to take us back to last Wednesday when I spoke to each one of you during board hour and let you understand and explain to you why you are sitting here. You know, normally we say, you're sitting in these comfy chairs, but because of the obvious you're not, you're sitting in these little harder chairs out here. But the reason that you 14 are sitting here is because last week you told me during the board hour process, which at the time all you told me, or all you were promised to do at that particular point, was to tell the truth. And by way of your answers, and me believing that you told me the truth last week, is the reason that you 14 are sitting here today. And based on what you told me last week, I'm going to ask you to do what you told me you could do and would do. And that's to follow the law. See, when we got started on Monday, prior to you hearing any kind of evidence or any kind of testimony in this case, you all stood up, you raised your hand, and you told us in this court that you would follow the law that is applicable in this case. And that's all I'm going to ask you to do. I'm not asking you to do anything outside of that. It's to simply follow the law. And in following the law, let's think about what that means for a jury. So as we discussed last week, yes, you're 14. But before you come 14, you have to be 1. So in looking at it and evaluating and making decisions regarding what you believe, how much weight to give, and that's all the information that's contained in this charge. We spoke about it last week, but now you have it here in writing. Is that each one of you, you're the ones that make the decision regarding how much to believe and not believe. Yes, the evidence that's been submitted to you for your consideration comes from the witness stand, absolutely. But that's it, just the admission of it. When you hear, no matter who did we talk about last week? We talked about witness credibility and the things you're supposed to make a decision and determination on. Whether it's an expert, whether it's a layperson, whether it's a police officer, whoever it is, when that evidence comes in, you make the determination what weight and how much credibility to give. You don't have to accept any of it. Just because it's admitted, you make the determination of how you want to evaluate it and how you want to use it. That's for each one of you. And then the charge, it also talks about the presumption of innocence. Presume innocent. Not until, but what unless? He's presumed innocent unless he's proven guilty. You hold on to that. You're charged with that. You've promised to adhere to that. And, you know, Mr. Barney said, you're going to hear a lot about beyond a reasonable doubt. Absolutely. And why shouldn't you? That's what this entire case is about, is reasonable doubt. And it is rampant. It's rampant throughout these proceedings. You see, here's the thing, ladies and gentlemen. The state has the burden of proof. They have to prove to each and every one of you, first individually, right? Individually, you have to make a determination of what you believe before you can even deliberate. You can't have a conversation with someone if you don't know what you believe, right? You have to decide. And then you make the decision. That's what it says. And you know, the misnomer in regards to jury duty is people think that a jury is, you're required to reach a verdict. That's not what you're required to do. What you're required to do is to listen to the evidence presented and deliberate. You're not forced into a verdict. You're not forced to agree. If you don't agree, that means you don't believe the statement is burden beyond a reasonable doubt. And if you do not, and you believe that they have not, then you're allowed to stand on that. And each and every one of you owes each other that respect of listening to that. So, regarding beyond a reasonable doubt, you ever heard the term quality over quantity? See, what the state has done for all these cases, you see, because I'm sure like you, or excuse me, like me, you all probably got confused on what case you were here for. Because they're bringing in all kinds of stuff, right? But ask yourself this, why? Because the case before you that you're just in charge of making a decision on, guilt or innocence, it's not Ms. Brooks, it's not Ms. Bartell, but it's Ms. Harris. And you're probably saying, well, why is all this coming in? And you know, the state says, and they're going to say, well, circumstantially, the relationships and the motive and lack of mistake and all these other legal terms that it's in the charge, take a look at it. But what you can't get caught up on is grouping all that together. Because see, the law allows you that you can, honestly, you can believe you wanted to that Mr. Schmimmer killed Ms. Brooks. But the state did not prove to you beyond all reasonable doubt that he killed Ms. Harris. That's what I don't want you to get caught up on. And that's exactly what the state wants you to get wrapped up in. You see, they've introduced almost 300 pieces of evidence, almost 30 witnesses, and 2 extraneous offenses for this one case. But Mr. Barney gets up there and says, this is real simple. Go back there and tell them real quick, we know what you did, convict him. If it was that simple, would they need all this quantity over quality? Because of all this evidence, and I'll use my air quotes, all this evidence the state brought you, right? What didn't they bring you? Because see, they're going to tell you all the things they did bring you. You know, some of the things that they want to bring to you, they want to argue is compelling. In regards, let's just talk about Ms. Harris. They brought you this money. Did they bring you any kind of bank document, draw slip, a bank teller, anything that said she went to the bank and withdrew these $2 bills? Nope. Her son-in-law said that, yes, she would give us $2 bills in Christmas cards. $400 $2 bills. Quantity, not quality. Mr. Varney gets up here, and they want to bring you invoices from Diamond Gold and Exchange from 2015 to 2018. Okay. We've never heard from the fact that he sold jewelry. But they want to say, and he quotes this number from 2015. It's in evidence, 288. From 2015, he made $91,000 selling jewelry. So, what does that mean? Absolutely nothing. Absolutely nothing. What did the owner say, Mr. Nassar? He said, yeah, we've been open since 2008. I said, you have some people that come in and they'll sell one piece and you won't ever see them again, right? Yeah, happens. I said, yeah, sometimes you have people that you've had that you've opened before, right? Yeah. Yeah, that happens. I've had them for years. This isn't abnormal. I said, that's good for business, right? Yes, sir. Mr. Fitzmartin said it's a business model. Repeat business. Quantity, not quality. So let's talk about these extraneous offenses. You know, because they're super hung up on this Nissan Altima. What I asked Sergeant Pagel, she's the supervising patrol officer for planning. I said, well, Sergeant, you're in the patrol division, which, you're on the highways, traffic tickets, responding to things. That's an extremely common vehicle, isn't it? Yes, sir, Mr. Warren, it is. So March 31st, they have maybe it's Nissan Altima. You look at the camera, you make the decision. Maybe it is. But what don't they have again? They can't identify a driver. They cannot identify a license plate. They can't identify anyone in the vehicle. More importantly, no one even gets out of the vehicle on that day. But they want to use that. Present that to you as evidence against Mr. Shamir. Think about the evidence they presented to you guys on regards to Mary Brooks. No direct evidence whatsoever. They talked about a relationship. How about a lack thereof? There's absolutely no connection whatsoever that they have here for you. None. No videos from Walmart. No videos from the apartment, the condo complex where she lives. No witnesses. That's kind of been a consistent theme with all these. And think about it. You have Mary Brooks, January 31st. You have Ms. Bartell, March 19th. And then you have Ms. Harris on March 20th. On all these days and times, not a single witness can place a vehicle or Mr. Shamir at their places of residence. Nobody. It's 2021 now, but even I submit to you in 2018, Ring doorbells, traffic cams, videos and cameras in apartment complexes, condos were rampant. Cell phones, everybody has something. Nosy neighbors, but nobody, not a single person in any of these alleged offenses was able to identify this man. And you say, well, Mr. Warren, but they brought in the FBI. They brought in Agent Sedgwick. And he showed us all this on this fancy map that they're going to put up. Mr. Fitzmartin's going to put it up. He's going to point to it. And they got their little pictures and everything. And they will say, hey, look at this. And you know what they're going to say? It's approximate. You know what the definition of approximate is? It's not actually, not exact. It's a guess. Could be. See the hot dog? He's somewhere in the hot dog. Or not even he. His device, if you believe that. Once again, you make the determination, you make the decision the way that you want to attach to it. Sure, he came in, he laid out his credentials, all these things. You make a determination if you believe that beyond a reasonable doubt. That's up to you. And you're here for the 20th, March 20th, 2018. So you say, well, we know he was at Walmart. We absolutely do know he was at Walmart. We saw it. What didn't we see? What didn't we see? What did Detective Sayers tell you when I asked him? No. Absolutely no contact whatsoever on that day between Mr. Shamir and Mrs. Harris. None. On all those cameras. And I guarantee you, if they had it, they'd have had it blown up and on another poster board and everything. They'd have had it for you, but they don't have it. Also think about the fact that on video, Mr. Shamir left 2 whole minutes before Miss Harris. But he's hunting. Oh, I guess he was hunting those dozen eggs he bought in the Dawn soap. Then he left before her. He drove away before her. Almost another 2-3 minutes. But they say he's in that area, so that's enough. It's not enough. That's not beyond a reasonable doubt. That they allege that he was there in the area, so is that good enough? I listened to you. I spoke to you all last week. We had conversations on this. I know it's not enough for you all. Here's another interesting thing. In the report submitted by Agent Sedgwick, on all the other days, on January 31st, on March 19th, they have all the hot dogs. Remember we called it the hot dogs with the approximation of the distance? Why not on March 20th for the case we're here for? That not seem odd to you all? On the day that's most important, because that's why we're here. Don't get lost in the mud. We're here on the 20th. That's why we're here. That's what they've alleged, and that's what they have to prove beyond all reasonable doubt. But like I tell you, for them it's quantity, not quality. And even speaking of the phones, we have evidence from their own witness that he had his phone. He didn't even have his phone the weekend of March 17th, 18th, and 19th. He didn't have it.
Objection, Your Honor. That is a misstatement of the facts. That witness said he didn't have it for that morning when he picked him up from the hospital, but he returned it to him later that day, on the 17th of them. That's a misstatement of the facts. I ask the jury to disregard that.
Ladies and gentlemen, the argument of the lawyers is not testimony. It is simply argument by the lawyers. You will recall all the evidence and testimony that you heard from the witness stand.
You recall it the way you remember it. You heard Mr. Odin. You heard him. Then they brought in retired Detective Saber. Good detective, known him a very long time. When I asked him those questions about the room, he said, I wanted to say the first 48 room, that's the room, that's the famous room from the TV show. And I asked him, I said, well Detective Tabor, what are those tactics you use when you speak to someone? He goes, yeah, well, we have tactics. Or that's what Mr. Fitzmartin described as tactics. But really, they're lies. And think back, when he spoke to the plaintiff detectives, they lied to him too. But they couldn't catch him in a lie, could they? The detective kept saying, well, it was on the 17th, it was on the 17th regarding the enterprise. Mr. Schmerner is very consistent and steadfast to know the 19th. And they had to concede, the state had to concede that it was actually the 19th when we rented the car. We're going back to Detective Tabor. All those tactics that he used. And you watched it, you saw it, you heard it. Try to befriend him, try to get personal, try to get some rapport, a relationship. Hey, Bill, you believe in God? Think you're a good person? Yeah. Yeah, I do. Yeah. For all those tricks, for all those lies, for all those tactics that he used, what I asked him, I said he was extremely consistent in denying that he had killed anyone. Mr. Barney says, well, he didn't ask him, who or anything or what. When you don't kill anyone, you don't have to ask who. Because it doesn't matter. I didn't kill anyone.
And he was consistent on that. And you know, so you say, well, Mr. Warren, but what about the stuff? About the stuff he had when he got arrested? The beauty of that is, we don't have to prove when, where, or how we got that stuff at all. They have to. They've alleged it. They've charged it. So they have to prove it beyond our reasonable doubt. We're not charged with that task. We don't have to respond to that. So whatever, you can think that, you know, because regarding the white truck and the Hispanic fellow that he got it from, that's what he told the detective, you remember? Did they bring anything to the contrary of that? Those items that are contained in the jury box, he said, I bought the jury box as a whole. Took out what I wanted, threw the rest away. But we don't have to prove that to you. It's not our burden. It's absolutely not our burden. You know, in any case, no matter what it is, you start with whether you're a prosecutor or a defense. Can you place the defendant at the scene of the crime? Because you can't place them there, then you have what? You have the wrong person. And what is consistent regarding these cases? Ms. Brooks, Ms. Bartell, and Ms. Harris. They can't place him there. You know what? They can't place anyone there. Going back to Ms. Brooks, you have a seasoned officer, Sergeant Harris, or acting Sergeant Harris, depending, I guess, the weekend, told you, and you saw it. He said, for peace of mind, let me double check her just to make sure I don't see anything. So you saw it, checked her neck, checked her back, checked her abdomen. No evidence of any apparent injury. Calls it in, hey, we're good. Natural cause. And so, you know, with Dr. Bernard, he says, well, you know, initially that was the case. And I asked him, I said, so what was different between that initial assessment and when you changed your, because that's what he did. He changed his, or their, however you want to describe it. When I say their, Dallas Medical Examiner's Office, when they changed their findings. And it's the same thing I asked the doctor the other day. I said, well, can the situation change your medical findings? He said, well, no. How will we take that into consideration? See, nothing changed in regards to how they found Ms. Brooks, or the injury or lack thereof on that day. But it fit their little formula. That's what it is. Their little formula. And it just so happens that they believe that Mr. Shamiri fits into it also. So they start here and they work backwards. And one of the things, and here's another interesting fact for you guys to ponder. So he said, one of the things is when they started, we received a phone call after the fact, after our ruled after that, after our being released to the funeral home, after all these things, we received a call about some things were missing from her daughter. Her daughter called that some things were missing. What was missing? There was a safe missing. It was once screwed in the closet. Okay, so it was bolted in the closet. Yeah. It's also about this rubber band, the technical security she had on that, where the printer and the safe was, right? Of all these, probably 220, 30 photos,
Do we see a single photo of that open closet where a safe allegedly was?
You have 7 minutes.
Thank you, Your Honor. Does that make sense to you? Wouldn't that, don't you think that would have helped you in reaching a certain conclusion of maybe getting beyond having a reasonable doubt? So ask yourself, why? Why didn't they take a picture of the shelf? She said it was a spoon, a broken, or a bent spoon, and it's been pried up in a way. Can't find it. Also, according to their theory, that Mr. Barney said that he sees a dollar sign. You saw the photos. You can look at the photos again, Ms. Brooks. There was a lot of jewelry that could have been taken. And the amount of time they alleged that someone would have had to be in there, well, we had taken all those. A whole big jewelry stand on the left side, and then on the right side was where she keeps her everyday jewelry. It's their theory. This is what they have to prove beyond reasonable doubt. You know, a baseball analogy is tie goes to the runner. In a court of law, when we're dealing with a criminal offense, the tie goes to Mr. Shamir. You don't give the benefit of the doubt to the state of Texas. You don't give them, they got close. We talked about this. We talked about this for almost my entire time before dying. It's about beyond a reasonable doubt and being able to hold the state to its burden. You don't get to help them. And I told each and every one of you, it was a hard scenario. A lot of people struggled with it. If they only proved 5 or 6 or whatever it is the elements are, would you be able to do it? Might sting a bit. But would you be able to do it? Each one of you told me. And that's why you're sitting here, that you'd be able to follow the law. It's another thing we spoke about. The difference between what? Innocence and not guilty. You might be sitting there thinking, well, Mr. Warren, he's not innocent. Maybe he is, maybe he's not. None of us were there. Because see, Mr. Barney said, forget reasonable doubt, it's beyond all doubt. Well, we all know that's a lie. It's not possible. Because in order for it to be beyond all doubt, it would have to be what? You'd be a witness, right? So it's not all. That's just silly. Innocence or it's not guilty. You see, the difference is what? We talked about it in 4 hours. Innocence means the person didn't do anything. Not guilty means that they can't meet their burden, they didn't prove it. And that's where we are. That's where we are. The same way Mr. Marty stood up here and said, I want you to go back there and come back with a quick verdict. I'm okay with that. But the verdict would need to be not guilty. Because I submit to you without a doubt, I don't have a doubt in regards to them not meeting their burden beyond all reasonable doubt. And as each one of you go back there, because, and I say each one, because each one of you has to make your own determination first. You have to decide. You have to look at each and every bit of evidence. You have to make a determination of which witnesses you're going to raise their credibility or lower their credibility, or which evidence, how much weight you're going to give particular evidence to making a determination of whether or not they met their burden. And once you do, once individually you do, then you deliberate. And I'm not telling you not to listen, I'm not telling you not to participate. But I'm also telling you that you have the power and the right not to change your mind. And your other members of the jury need to respect you. You need, and the same, you respect them. Ladies and gentlemen, over these last few days, like I said, you listened to a lot of testimony. You've seen an exorbitant amount of evidence and items put in. But we're talking about quality and not quantity. And I'm gonna end my argument the same way that I ended my board doc. I'll remind you the same way last Wednesday. Before I sat down, I asked each one of you, I said, you know, and I looked each of you now like I'm doing now, and I said, if you were the individual sitting in that chair over there, would you want you as a juror? And I said, I want you to think about that. And what that means, would you be able to be fair and impartial and actually listen to the evidence? Not what the popular opinion may be, not with wanting to feel like a good citizen and doing what the state of Texas requests you to be, but actually doing what's right and what you've promised to do, which is follow the law. And each one of you, the reason you're sitting here is because you told me that you would want you as a juror, and that's what you would be able to do. And I'm not asking any more or less than you than that. Thank you for your time and your attention. And we look forward to you deliberating. We will look even further toward you acquitting Mr. Schmimer. Thank you.
Thank you, Mr. Warren.
May it please the court?
Okay.
Ladies and gentlemen, why does it have to be quantity or quality? Why can't it be both? Why do we have to choose quantity or quality? Why can't it be both? That's what we brought you this week, quantity and quality. This is the first time in my career as a prosecutor I've been accused of bringing too much evidence into a court. But that's what I did with you all. I told you when I got up in here in opening statement that at the end, there's three things you need to look out for. You need to look out for, number one, they both left Walmart at the exact same time. Maybe 2 minutes off, but they were both there at the same time. Did I prove that to you? Absolutely. I had to prove to you that he was in possession of her property 2.5 hours later. Did I prove that to you? Absolutely. And I had to prove to you that she was smothered. Did I prove that to you? Absolutely. Now, those are the only three things that I really needed to prove to you in this case that happened in Dallas County, state of Texas. But if I prove those three things to you, then you should return a verdict of guilty, and a swift verdict of guilty. Now, I also told you that I know, and I've read your jury questionnaires. Y'all didn't talk a whole lot. You're the quiet ones that were left behind, okay? But I read through your questionnaires. And I know that a lot of you watch CSI, and you listen to podcasts, and you listen to crime dramas, and you look at all those things. I've listened to them. I've watched To Make a Murder or whatever, or The Serial and all that. And I know that this day and age, people want more. They want all of those questions answered. Well, ladies and gentlemen, I have answered all of those questions that you could possibly have. Now, did he leave the scene in such a way that trained professionals could detect that he had been there? Absolutely not. What does that tell you about him and his abilities? It tells you he's good. It tells you he's very good at what he does. He is efficient. He is good at picking out those people. You saw him on March 15th. You saw him walk in for a few minutes and walk out and survey and survey. You saw that. You saw him again on March 20th at that same location. You know he was in that Altima back on January 30th. You know it. You know it because on March 15th, that same Altima shows up, and he walks out of it wearing the yellow tie. The yellow tie he told the detectives he was wearing on March 15th. Right? It doesn't have to be just quantity or just quality. It can be both, and that's what you have in front of you. I brought you everything I could find, everything, every record, everything we could do to make sure that if you were one of those one skeptical time, I have to prove it to all 12 of y'all. And so I'm looking, I don't know if it's you, if it's you, if it's you, or if it's you, that needs just a little bit more. So I went that little bit more. Just that little bit more, and that little bit more, so that there wasn't anyone who could come back and say the state of Texas didn't do their job and didn't present what they could. The detectives, when they got onto this, when they got onto Billy Chimerier and knew that he was out there stalking and hunting in our community, they went full bore to try to investigate this case. My office did the same thing, went full bore. You saw this judge give him a fair trial. You know these lawyers are good, and they would not be sitting at this table if they didn't, and they put on the best defense that Billy Chimere could have. And now the job is turned over to you all. You have to take this evidence. You have to consume it, you have to deliberate on it, and you have to return a just verdict. And there is only one just verdict in this case. And that is guilty of capital murder. Not because I say it or because I want it to happen or anything like that. It's because it is what the evidence has led us to know. On March 20th, you know that the Plano Police Department are starting to work on Billy Chimere. Why? And they say, which case am I talking about here? I'm talking about the state of Texas versus Billy Chimere. That's what I'm talking about. That's the only case you need to worry about, is the state of Texas versus Billy Chimere. Okay? And so I told you, in order to tell the events of March 20th, I had to go back to March 19th. And I had to talk about Mary Bartell. And I had to. And how is it that Mr. Chimere is the most unluckiest individual ever, that on his offer-up account, he is selling a very unique ring that belonged to this woman? On January 30th, he is selling this very unique ring belonging to this woman, both having been attacked and smothered. And a few hours later, from this woman, Lou Harris, being found dead, he's got her property. The most unluckiest of individual ever. He just keeps falling into the property of people who have been smothered. Is that possible? No. And that is why Mr. Barney says we have proven this beyond all doubt. Because it is just not possible. It is just not possible. Now the phones, why do we go through all of this? He's on his phone, and his phone puts him there, in that picture. He is on his phone, and his phone puts him here, in that picture. He is in this, at Enterprise, and his phone puts him there. Now, we don't have him there. We don't have someone who says, yes, I saw him put a pillow over Mary Bartell's face, but his phone puts him there. March 15th, the minute he gets identified by someone who comes up and talks to him, what does he do? He runs off. He runs away. Right? So the minute he's confronted, he takes off. So you want to know why we don't have anybody? You know what I've often thought in looking at this case with Miss Harris? And the way she exits that Walmart and turns right, having him go out before her? What if she had gone out the other way? What if she had gone out the other way? Would she still be the hoot that Rick called her? Would she still be able to be generous, a generous soul that he described her as? Would she still be bringing joy and love to her family?
Judge, I'm sorry, I'm not the judge, but that's an improper argument.
Ladies and gentlemen, the argument of the lawyers or the statements of the lawyers are purely arguments. You have heard all of the evidence or testimony that you will receive in this case. The statements that you hear from the lawyers during the argument is not evidence. Thank you.
Ms. Harris. He said this is how she looks in this picture, how she presented in life. This is how Billy Chimere thinks of her. Discarded, like the pieces of paper or whatever's on her head. That's what he turned her into. Nothing. Doesn't even care. And what do they say? Well, we don't have to explain all this stuff. We don't have to say who the guy is that had her name or her Kim necklace or this green ring. We don't have to have the exact bracelet that she's in that picture on. We don't have to come up with why he still has keys that unlock the doors to her house. We don't have to explain that away. We don't have to explain why her handwriting is in his possession. We don't have to say why this jewelry box is in his possession. Well, remember we showed you this jewelry box? Now keep in mind, on March 20th, he's in that Sonata, having rented it the day before. There's very few items in that car, okay? There's some diapers from the morning. He said he bought some diapers at Albertsons. He said he went to Walmart for some eggs and some Dawn dish soap. Okay, that's in the car. There's, in the backseat, he got some food from the African Fusion place. And there's some bottles of wine that he went and got in there. What's the one odd thing that's in that car? A hammer. Why is there a hammer in the back seat of a rented car of Mr. Chimerian? Well, you have the damaged jewelry box. Somehow you had to get in to the jewelry box. Well, doesn't it seem logical that he got himself a hammer? Now I can tell you, he didn't go back to that same Walmart there to get that hammer. There would have been video of that. But somehow he comes up with this Walmart hammer. We know that there's a Walmart right on his route home that he takes, right down here at Montford and Beltline. I don't have video from that store. Didn't know he did. It's gone. Now, if this guy in this white truck has this jewelry box, and I just picked out the parts I wanted or whatever. Okay, well, did you look through it ahead of time and just buy the stuff and the guy keep it, or you bought the whole box? Well, then why are you trying to get into it later on with the hammer, and how did you know you even needed a hammer? Doesn't make sense. It doesn't make sense. They have the luxury of just saying that we don't have to do that. And that's true. They don't have to do anything. But it's been 3 years. They have the same subpoena power we do. They can issue subpoenas if they want to. Okay? And if there's a Hispanic male out there on Spring Valley that's selling this stuff, I'd sure like to meet him. Why did I not produce evidence to the contrary? How do I disprove that? That there's a fictitious figure out there in a white pickup truck selling jewelry on the side. Yeah. Oh, hey, I see you've got. I see you. We bought from each other before. Okay, yeah. I'm gonna go get some food. Come meet me at my house, and I'll go buy from you there. Wait a minute. We were watching you. Oh, not at my house. At the house next door, in the area next door. That's where I was buying it from. Okay, how much did you spend? $700. This is 20 minutes. This is right before he was arrested. And he doesn't know the exact amount he spent for this jewelry? Come on. I mean, did you hear? I mean, I hope it was obvious to y'all, and I hope I'm not wasting your time. I hope I didn't waste your time after, really, once Detective Sayers got on the stand and put in the videos from Walmart on March 20th, I hope you don't feel like I wasted your time going through all of the other evidence that I have. But I have to make sure that everything is done in this case. And that you see Billy Chimerian as I see Billy Chimerian. Not necessarily through my eyes, but through Mary Brooks' eyes, through Mary Bartell's eyes, and through Lou T. Harris's eyes. Because that's the last face they ever saw. Not the face of the loved ones that were surrounding them maybe in their final days. Not their grandchild who lived just right next door that was there to kind of make sure that the grandma was okay. Not Rick who lived a couple of...
I'm sorry, that's an improper argument for this, during this time of the proceedings.
Ladies and gentlemen, you have heard all the evidence and testimony from the witness stand in this case. And once again, the statements and arguments made by the attorneys is not evidence. Thank you.
Nations will be measured by how they treat the weakest of their members. That's what Mahatma Gandhi said. Our society will also be judged by how we treat the weakest among us. If you look at this evidence, you know, we asked you all to do a lot of things down here. We asked you to come down last Wednesday. We asked you to come back this week. We asked you to, keep away from your family and friends. Don't talk to them like you normally would. We asked you to kind of work on our schedule. We asked you to stay late yesterday. We asked you, maybe you're news buffs, and told you don't watch the news anymore. Okay? Don't talk to your friends and family and about these things. And maybe some of you all have lost money this week because you've had to come down here rather than go where you're supposed to go. One thing we don't ask you to do is to give up your common sense. No one asked you to check your common sense at the door. You know, common sense is genius dressed up in its working clothes. Emerson said that. And I'm asking you to draw upon your common sense here. What are the possibilities of this taking place and this being the most unlucky man? It's not possible. All this evidence we brought you, these 300 pieces of evidence, boiled down to basically he's at Walmart, she's smothered, and he's thrown out her stuff. It comes down to that. And I apologize if I brought too much evidence. I apologize to y'all right now. But I will do it today, I'll do it tomorrow, and I'll do it in every case that I do. Because that is what we are called upon to do in this side of the aisle. And now you are called upon to render a just verdict. And as Mr. Barney said, I don't expect this to take you very long. It should take you probably longer to pick your foreperson. Because there's really nothing that you all need to discuss beyond your own deliberations. Thank you.
Thank you. Well, ladies and gentlemen, that is all the argument that you will hear in this case from both sides. We are now in your hands. I am going to give the charge to our bailiff. You are now instructed that you may deliberate. We are back on the record in cause number F1875401. It's the case, the state of Texas versus Billy Shamirmir. Once again, this offense is a capital murder by terror, threat, or other felony. The jury has sent out a note at 7:43. They sent out a note indicating that they wanted to work tomorrow morning, that they wanted to end their deliberations tonight, and that they wanted to work in the morning. That note was read and presented to the defense attorneys as well as to the state, and a response was sent back to them indicating that yes, they may return in the morning. So is there anything further that needs to be put on the record by the defense?
Yes, Your Honor. Your Honor, this time it is now approximately 7:48. This jury has now been deliberating for the last 4 hours. We are aware of the note that they just sent out regarding they would like to cease deliberating this evening and return back in the morning. Judge, since, actually, beginning last week when we selected this jury, and especially this week on Monday when we began testimony, and even more so this afternoon upon closing arguments and the jury receiving this case for the deliberations, there's been continuous media attention and publications regarding the information contained. Not only information is received this week in this particular proceeding, but also even today on, I can't remember which site, but there was an article that was released online that said, basically referencing the other cases that he was indicted on. I believe that it would prejudice Mr. Shamirmir for this jury to separate and to go home and have access to social media, internet, printed media, access to their phones and other people, family members, friends, maybe not intentionally, even if it's unintentionally, speaking to them, sharing with them different information that they did not, have not, and would not receive in this courtroom. And based on those things, Judge, we're going to ask and move this court to sequester this jury as they deliberate.
State, any response?
Judge, we'll just leave this up to your discretion.
All right. So, having heard the request by the defense, that motion will be denied. The motion for sequestration will be denied. The jury will return in the morning. They have been admonished. They have the admonishment in writing from the court regarding no media, no discussion, no deliberations outside the deliberation room. They were also admonished of that prior to leaving again today. So that motion will be denied.
Thank you, Your Honor.
Is there anything further from the defense or the state?
No, Your Honor.
All right. And we have already discussed that in the event that a verdict does come in, that another district judge, as a matter of fact, the presiding judge of the felony judges will sit in my stead. So all parties are aware and understand, correct?
That's correct, Your Honor.
Yes, sir.
All right, thank you. So we are off the record and we will resume tomorrow. Thank you.
Thank you, Judge.